Any memos? Someone give data. Any adjournment? These two? Page 6, serial number 23 to 29?
Number 26. Waiting for the petition.
For the petitioner, please sort out. Yes.
Page 7, serial number 30 to 32. List 1, page 1 for non-compliance of office objection for second time, serial number 1 to 3.
Counsel for the petitioner is absent, no representation. List for complaints. Next.
For non-compliance for third time, serial number 4, Signatory.
List number 3.
1 minute. 3, 4 to 10.
Serial number 5 to 10.
Yellow, pass over, madam. 5 to 10.
Serial number 6. Serial number 6, my lords.
Serial number 7.
It will become infractious, my lord. It's an state appeal, my lords. We have challenged the examining of a witness, my lord, that we have challenged because opportunity has not been given to the public prosecutor to cross-examine CW1, my lord. In the meanwhile, the honorable court has passed a judgment by acquitting the accused person, my lord. Thereby it is.
Additional SPP submits that the petition is rendered infructuous as the hence pays for dismissal of the petition. Submission is placed on record. Petition is dismissed as the same is rendered infructuous. Yes.
Non-compliance for fourth time, serial number 11 to 13.
My lord, serial number 7, my lord. Kindly grant 1 week, my lord.
Peremptory order, other. 7.
Peremptory order.
No, final.
My lord, I'll file memo. I may be permitted to withdraw and liberty may be allowed.
7.
7, my lord.
Why you are seeking time? When the memo is ready, why you are seeking time? You should avoid this conduct, sir.
My apologies, my lord.
You should be straightforward. You should be true to the court.
Yes, my lord.
There cannot be any hide and seek.
Please, ma'am.
Why you are sought for time? You are testing the court, is it? How it will benefit you? Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Petition is dismissed as withdrawn. Next. Yellow. Also yellow. Yes. Yes,
List number 3, my lord. Serial number 1 week time may be.
Serial number 2.
1. List number 2, 3, serial number 1.
Serial number 1.
Maheshwarappa. Praise for time.
My lords, list 2, serial number 11, my lords.
Await report is wait for some time.
My lord, list 2, serial number 9, my lord, it becomes a petition become infructuous as petitioner is not interested contest.
9.
9, my lord.
List 2, serial number.
Serial number 9.
Counsel for the petitioner filed a memo reporting,
My lord, petition is not interested to contest.
reporting that the petitioner is not interested in prosecuting the petition. Memo is placed on record, petition dismissed. Next.
List 2, serial number 21, my lord. As for the respondent, seek for short accommodation.
Wait. Let him come.
List
Counsel for
serial
the
number.
petitioner, let him come. Let him come, let me see. No done.
Please.
Wait for some time. Next.
These two, serial number 1 for further hearing, Shivananda DS.
Petitioner, my lord.
This one.
Third day, my lord, the matter was heard, my lord. Only for the purpose of, because they have not filed any appeal, my lord.
One.
I made submission, but he has taken time.
Hmm. 498 A, my lords.
1 minute, 1 minute.
Maybe adjournment.
Yes,
The OS number 45 or 2021 was decreed, my lord.
Hmm.
That's true. Subsequently, my lord, the divorce petition is also allowed. They are separated now, my lord.
divorce petition is OS 45 of 2021.
Yes, that
Ah.
is, yes, madam, yes.
That was decreed.
45.
That
And
was
28, that is allowed. Restitution conjugative was allowed.
Hmm.
Subsequently, divorce petition also allowed.
Yes,
Because now
Appeal?
last time he sought time to know whether appeal is filed or not.
Hmm.
Appeal has not been filed so far.
no appeal.
Yes.
No appeal is.
No appeal, no. Even yesterday also he was there, but the matter was not reached.
Yes. Yes,
Yes, my lord, the allegation, sir, he has cheated her by saying that he is an engineer, my lords. And
but the
previous-
invitation does not
Yes, my
speak
lord,
so.
on the previous occasion only it was clarified that in the invitation card, his qualification is
Appeal
mentioned, my
remains.
lords.
Marriage is already dissolved. It is not challenged.
Yes, my lords. No appeal has been prepared. my lords.
Yes,
Yes, my lords.
peruse the materials. Peruse the material. Respondent number 2, absent.
DC Shanmuga.
Learn counsel for respondent number 2 or absent at pardon only. Peruse the materials on record. Point for consideration. My answer to the above point is in the affirmative for the following reasons. The petitioners being accused number 1 to 6 are seeking to quash the FIR in crime number 326 of 2018. Which police station?
Second respondent.
One,
One
yes,
As per the inspection, my lord, there is no appeals.
right. Bedi ಏನಿಲ್ಲ. I'll proceed. ಅದ್ ತಗೊಳ್ಳಿ, absent ಅಂತ ಬೇಡ. Learned counsel for respondent number 2. Even though opposes the petition and seeks for dismissal of the same, fairly concedes that respondent number 2 had not challenged the victim resolving the marriage rather than verse 45 of 2021. Accordingly, he prays for passing appropriate orders. Perused or allowed. The petitioners being accused number 1 to 6 are seeking to quash the FIR registered in crime number 326 of 2018 of which police station?
Honanhalli,
Not-
Davangere, my lords.
Honnenahalli of Davangere, registered for the offence punishable under section 498A, 420, 323, 506, read with section 149 of IPC.
Honnali ಇದು. That is
And
not
under
Honnenalli.
section 3 and 4 of
Okay.
Recovery Prohibition
Honnali.
Act. Prohibition Act. Now pending.
Madam.
CC number agide. On the file of the learned principal civil judge, junior division and JMFC, Honnali, Davangere district. Respondent number 2 has complained.
Challenged on the FIR, my lords. There was a stay, my lords.
Okay, CC number again. Making specific allegations that she had married accused number 1 on 6/3/2016. At the time of marriage, dowry was demanded. Accordingly, gold ornaments and cash were paid to accused number 1. After marriage, she had been to her matrimonial house, where all the accused have treated her with cruelty and physically and mentally ill-treated her.
15.
As respondent number 2 could not tolerate the ill treatment, she came to her her parental house. But when she received the information that husband is returning from Saudi Arabia, went to the matrimonial house, but the accused have not permitted her to enter the house. On the other hand, demanded additional dowry. And thereby they have committed the offense. It is also stated that at the time of marriage, the respondent number 2 was cheated by accused number 1 by stating that he is a engineering graduate. Next. The materials on record discloses that in the marriage invitation card, accused number 1 is described as a BCA IT EXC degree holder, and he was never described as the Bachelor of Engineering. Moreover, it is the admitted fact that respondent number 2 was residing in her parental house. And accused number 1 filed OS number 28 of 2018 seeking restitution of conjugal rights. The same was came to be decreed on 27/1/2019. The said decree was never complied with by respondent number 2. Later, accused number 1 filed the suit OS 45 of 2021 seeking dissolution of marriage, and the said suit was going to be decreed on 7/12/2021. Admittedly, the decree for dissolution of marriage is also not challenged by respondent number 2. The first information was came to be filed on 30/8/2018. That is apparently after filing of the suit was 28 of 2018. There are absolutely no basis as to why such allegations were not made earlier. The first information filed which coincides with the filing of the suit by accused number 1 for restitution of conjugal rights, give rise to prima facie inference regarding the intention on the part of respondent number 2. It is pertinent to know that respondent number, it is pertinent to know that the petition number 1 is the husband, and the 2 to 6 are his family members. Even though several allegations are made, the same does not refer to any particular date. When prima facie, it is shown that there was no cheating by petition number 1 regarding his educational qualification, and the marriage of the petitioner with petition number 1 with respondent number 2 is already dissolved by a decree of divorce dated 7/12/2021. I'm of the opinion that continuation of the criminal proceedings against the petitioners would amount to misuse of the due process of law. Therefore, I am of the prima facie opinion that the petition is liable to be allowed by quashing the FIR registered against the petitioners. Accordingly, I answer the above point in the affirmative and proceed to pass the ballot. Petition allowed.
A further argument, serial number 2, that Mutually, H. Srivatsa, Chetan Angadi.
Lords, on the other day, my lords, I was making a submission that, my lords, apart from the proceedings which are impugned in this petition, we had also, my lords, initiated a complaint. And also it's a fact that, my lords, when the petition was filed, we had a company petition, my lords, before the company law board, my lord, which was being heard.
Yes.
My lords, what happened, my lords, the proceedings which were there before the board, my lords, the board felt that it may not be appropriate for the board to look into all the aspects because serious allegations of forgery and other, my lords, other aspects were alleged.
Yes.
And my lords, we were asked to go to a civil court. Thereafter, my lords, we filed an appeal before this honorable court. Your lordships are having, lords, if your lordships are having the memo for documents, which I have filed
Yes.
on, my lords, 5th October 2020. My lord, our division bench order of this honorable court, my lord, according to me, my lords, has a bearing, my lords, insofar as this,
Any synopsis or dates and events?
my
No.
lord, that has been filed, my lords, long back.
When?
Not sure, my lord, but
Where can
it
I
was
find it?
quite some time back, my lords. Right now, I do not have.
Sometime back means?
In fact, my lords, along with the list of documents which I am referring, I have, my lords, enclosed the synopsis. That was filed on, my lords, 5th October 2020. Lord, memo of documents.
Who is Prakash Buddur?
My lords, I'll take you. He, my lords, was appointed by his brother. He filed a suit, my lords, against.
Not an accused.
He is not an accused. He files a suit, my lords, against the second respondent. Gets an order of injunction. to the effect that, my lords, he will not transfer the shares. My lord, that fact, my lords, was suppressed. In spite of that, my lords, he says there was my lords, an agreement which was produced, and files a complaint. Actually, an injunction was operating against him at that time, my lord, restraining him from transferring of shares. That he doesn't disclose. My lords, for a moment, my lords, if I take your lordships to the document number 2, my lords, which is the order of division of this honorable court, at page number 23, my lords.
Yes.
We preferred, my lords, an appeal before this honorable court, being agreed by the
Against the order of the company law board.
yes, my lords. Where, my lords, we were asked
Who
to
approached, accused number 1 approached.
accuse number 1. If your lordships kindly see, my lords, respond number 2 is Madhukar Angor, complainant in 7789, and Priyanka BS. She is the complainant in the other case. Also, my lords, the business, my lords, Alliance Business School, my lords, was party respondent. My lord, it binds all of us. My lords, for the purpose of my lord, just I'll go, my lords, briefly into the, my lords, facts narrated. So that, my lords, I can appreciate, my lords, the contentions, my lords, and the findings of this honorable court, my lords. Page number 25, my lords, starts with, my lords, that is inter page 3,
Yes.
judgment. The present appeal is directed against the order dated.
So sorry, sir. Come to the relevant portion.
Please, my lords. My lords, my lords, there is a discussion about, my lords, about the cases, and the fact that, my lords, we were asked to, my lords, go to the civil court. My lords, I take your lordships, my lords, to the my lords, very relevant findings, which concerns, my lords, also the, my lords, this honorable the case before this honorable court also, my lords.
Yes.
If your lordships kindly come to, my lords, page number 52, my lords, that is 74. In page 74, my lords, internal page 52 of the order. Para 38, my lords.
Ultimately, this appeal was dismissed.
Yes, but the observations, my lords, your lords may, my lords, consider. Para 38, my lords.
Yes.
We may record that by now it is well settled that the jurisdiction of the CLB is summary in nature, more particularly when by express omission of the power which is possessed as per earlier provision of section 111(7) of the Act of 1956. Further, the CLB has no jurisdiction to examine the genuineness of the documents, more particularly when in a criminal case, the charge sheet is filed on the premise that the documents are not genuine and are forged documents. It cannot be said that the jurisdiction of civil court is barred, since the civil court would possess the jurisdiction for deciding interstate dispute between the parties, unless the jurisdiction is impliedly or explicitly barred by any statute. Further, it is only in the civil court proceedings there will be sufficient opportunity to the appellant to prove that the document transfer are genuine by examination of his witnesses and the cross-examination of the witnesses of the respondents 2 and 3. As such, in a matter where, in the criminal proceedings after investigation, it is found that the documents are forged and not genuine, it would be more appropriate to relegate the party to the civil court for proving the genuineness of the document, including by proving the signature, because the civil court will have competence to make appropriate declaration in this regard, irrespective of the investigation made by the police in the or the criminal case. Lords, I pass, lords, here for a moment. What this, lords, according to me, lord, this honorable court means that, my lords, irrespective of any observations by the criminal court, lords, the civil court, my lords, has authority and jurisdiction, lord, to decide otherwise. Further, my lords, after the genuineness of the document is so proved and the appropriate declaration is made by the civil court, unless otherwise prohibited by any competent forum known to law, CLB will have power to direct company to transfer the share in favor of the appellant, but until such a declaration is granted by the civil court, CLB may not be in a position to issue declaration in direction to the company to transfer the share, for the simple reason that unless the documents are found to be genuine, including signature thereof, the question of effecting transfer of shares or issuing directions for transfer of shares may not arise. Under these circumstances, we do not find the CLB has committed any error in exercise jurisdiction in relegating the appellant to approach before the civil court for getting appropriate declaration about the genuineness of documents for transfer of the shares in their favor. My lords, my respectful submission is, my lords, even if, my lords, according to my lords, even if for a moment it is taken, that alleging that there is fabrication or anything, charge sheet is filed, criminal proceedings are conducted, and ultimately, my lord, if it reaches conclusion also, I can still establish that it is otherwise. My lords, as such, my lord, my respectful submission relying on the observations of this honorable court, where we, my lords, all of us are party. My lord, myself, my lord, the complaints in both, my lords, of both the cases.
Now the question is,
Please,
the civil court holds that the documents are concocted and the signatures were
please.
forged.
My lord, at that time, my lords, they can, my lords, seek for, my lords, the relief, my
revive
lord,
the-
perjury, my lords, other proceedings can still be done, my lords, initiated. It's not that, my lord, it cannot be done at all.
Yes.
It is not good, my lord.
Yes. ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರಿ. Senior
ಅಂದ್ರೆ
ಬರ್ತಾ ಇದ್ದಾರೆ, senior ಬರ್ತಾ. Since 1 week you are saying the same thing. You are not fed up with that. ಬಿಡಿ. Yes,
My
anything?
lord, the main question for consideration before this honorable court is that, my lord, whether the criminal proceedings can be continued when the same issue is before the civil court, my lord. My lord, my submission is that, my lord, the standard of proof required in both the cases are different, my lord. Whereas in the civil court, my lord, it depends on the preponderance of
Other
probability.
day I asked
And
you, what will
the,
be the.
Yes, my lord, I'll submit, my lord. I may be permitted to make my
Hmm.
submission for 2 minutes. My lord, my submission is that, my lord, the criminal proceedings cannot be quashed merely because the civil suit is also pending with reference to the same document. My lord, the earlier principle, my lord, in the year 1970, my lord, that was Karamchand Ganga Prasad versus Union of India, my lord. The earlier principle was that, my lord, the decisions of the civil courts are binding on the criminal courts, my lord.
Yes.
And the converse is not true, my lord.
Yes.
That was the principle followed, my lord, in 1970, my lord. My respectful submission is that, my lord, that judgment has been overruled by the Honorable Supreme Court in by a 3-judge bench, my lord, in KG Prem Shankar versus Inspector of Police. And my lord, I like to rely on that judgment, my lord. I request my lords to kindly take paragraph number 6. Page number 4 of the judgment, my lord. The contention raised by the appellant, my lord. The appellant raised additional contention before the High Court that the de facto complainant Madhavan had filed a suit for damages for the alleged acts before the subcourt Telecast against the appellant and other accused, and the trial court has dismissed the suit against which he had preferred the appeal before the High Court. It was therefore contended that as the suit was dismissed, the decision rendered by the civil court will prevail, and therefore the criminal prosecution pending against the appellant and others is required to be dropped. The court rejected the said contention, hence this appeal. My lord, the relevant portion of this judgment, my lord, is in page number 10, my lord, paragraph number 29. Sorry, my lord, paragraph number 30, my lord.
There the civil suit was already dismissed.
Yes, my lord. What emerges from the aforesaid discussion is the previous judgment, which is final, can be relied upon as provided under section 40 to 43 of the Evidence Act. In civil suits between the same parties, principle of res judicata may apply. In a criminal case, section 300 CRPC makes provision that once a person is convicted or acquitted, he may not be tried again for the same offense if the conditions mentioned therein are satisfied. If the criminal case and the civil proceedings are for the same cause, judgment of the civil court would be relevant if conditions of any of sections 40 to 43 are satisfied. But it cannot be said that the same would be conclusive except as provided in section 41. Section 41 provides which judgment would be conclusive proof of what is stated therein. Para 31, my lord. Further, the judgment, order or decree passed in a previous civil proceedings, if relevant, as provided under section 40 and 42 or other provisions of the Evidence Act, then in each case, the court has to decide to what extent it is binding or conclusive with regard to the matters decided therein. Take for illustration, in a case of alleged trespass by A on B's property, B filed a suit for declaration of its title and to recover possession from A, and suit is decreed. Thereafter, in a criminal prosecution by B against A for trespass, judgment passed between the parties in civil proceedings would be relevant, and the court may hold that it conclusively establishes the title as well as possession of B over the property. In such case, A may be convicted for trespass. The illustration to section 42, which is quoted above, makes the position clear. Hence, in each and every case, the first question which would require consideration is whether judgment, order, or decree is relevant. If relevant, its effect. It may be relevant for a limited purpose, such as motive or as a fact in issue. This would depend upon the facts of each case. In the present case, the decision rendered by Constitution Bench in MS Sharif case would be binding, wherein it has been specifically held that no hard and fast rule can be laid down and that possibility of conflicting decision in civil and criminal courts is not a relevant consideration. The law envisages such an eventuality when it expressly refrains from making the decision of one court binding on the other or even relevant, except for limited purpose such as sentence or damage. Hence, the observation made by this court in VM Shah case that the finding recorded by the criminal court stands superseded by the finding recorded by the civil court is not correct enunciation of law. Further, the general observations made in Karamchand case are in context of the facts of the case stated above. The court was not required to consider the earlier decision of the Constitution Bench in MS Sharif case as well as section 40 to 43 of the Evidence Act. In the present case, after remand by the High Court, civil proceedings as well as criminal proceedings are required to be decided on the evidence which may be brought on record by the parties. My lord, the same principle was followed by our Honorable High Court also, my lord, in the judgment of Balaji Trading Company and others. Para 13 would be relevant in this judgment, my lord. It's page number 15. The second ground urged before this court by the learned counsel for the petitioners is that when the appellate civil court is seized of the matter and the trial civil court has given its opinion that Exhibit D 1 to 10 are forged documents, but it failed to refer the complaint to the competent court. The question was different in that particular case, my lord. And further, an appeal is already pending before the first appellate court. Until the disposal of the civil matter, criminal case cannot be launched or proceeded with. This argument is also, in my opinion, not tenable, as the proceedings before the civil court and criminal court are altogether different. It is evident from the legal principles that the documents which are produced before the civil court can be proved to be forged by means of preponderance of probabilities, wherein such offenses have to be proved with reference to the documents before the criminal court beyond reasonable doubt. Therefore, more responsibility is casted upon the complainant to prove that those documents are forged in a criminal case, and in such an eventuality, the accused will get sufficient opportunity to question the said disputed documents. Further, added to that, this particular point raised by the learned counsel is also considered by the Honorable Apex Court in the above said decision at para 32 of the judgment of the Honorable Apex Court referred to Supra after considering his previous judgment in MS Sharif versus State of Madras, wherein it has laid down the principles which reads as under. Coming to the last contention that an effort should be made to avoid conflict of findings between the civil and criminal courts, it is necessary to point out that the standard of proof required in the two proceedings are entirely different. Civil cases are decided on the basis of preponderance of evidence, while in a criminal case, the entire burden lies on the prosecution and proof beyond reasonable doubt has to be given. There is neither any statutory provision nor any legal principle that the findings recorded in one proceedings may be treated as final or binding in the other, as both the cases have to be decided on the basis of the evidence adduced therein. While examining a similar contention in an appeal against an order directing filing of a complaint under Section 476 of Old Code, the following observation made by the Constitution Bench in MS Sharif versus State of Madras give a complete answer to the problem posed. As between the civil and the criminal proceedings, we are of the opinion that the criminal matters should be given precedence. There is some difference of opinion in the High Courts of India on this point. No hard and fast rule can be laid down, but we do not consider that the possibility of conflicting decisions in the civil and criminal courts is a relevant consideration. The law envisages such an eventuality when it expressly refrains from making the decision of one court binding or the other, or even relevant, except for certain limited purposes, such as sentences or damages. The only relevant consider here is the likelihood of embarrassment. Another factor which weighs with us is that a civil suit often drags on for years, and it is undesirable that a criminal prosecution should wait till everybody concerned has forgotten all about the crime. The public interest demand that criminal justice should be swift and sure, that the guilty should be punished while the events are still fresh in the public mind, and that the innocent should be absolved as early as is consistent with a fair and impartial trial. Another reason is that it is undesirable to let things slide till memories have grown too dim to trust. This, however, is not a hard and fast rule. Special considerations obtaining in any particular case might make some other course more expedient and just. For example, the civil case or the other criminal proceeding may be so near its end as to make it inexpedient to stay it in order to give precedence to a prosecution order under Section 476. But in this case, we are of the view that the civil suits should be stayed till the criminal proceedings are finished. From the above, it is very clear that the criminal proceedings cannot be stalled merely because the civil suit is also pending with reference to those documents. However, it is made clear that there is no hard and fast rule that both the cases can continue together, but for special consideration and on any special circumstances, if the civil case and the criminal proceedings, which are so near for disposal, and a ground is made out to stay either of the proceedings in such an eventuality, the concerned civil court can stay its proceedings till the criminal proceedings are finished, or vice versa, as the case may be, under the special and peculiar circumstances of the case.
Yes.
My lord, on the facts of this case, my lord, the charge sheet allegations are that, my lord, the accused number 1 has forged the signatures of the complainants in both the crimes, my lord. And the other accused, my lord, they are the witnesses to the forged documents, my lord. And it was also the argument of the petitioner that my lord, the original forged documents were not seized by the police.
Yes.
My lord, on last occasion, my lord, he made a submission that, my lord, the original documents were never seized by the police. And it was not sent to FSL also. My lord, after the registration of the crime, my lord, a police notice was issued to the accused number 1 to submit the original documents, my lord, as he claims that it is with him. And he has sent a reply to the notice, my lord, along with certain self-attested documents, my lord. And in the reply, my lord, he says that the originals are with him, and he has given those original to his counsel in Chennai because he has to produce those original documents in the civil proceedings, my lord. And he says that, my lord, these are the documents, I attest this as the original documents, and these are the signatures, my lord. He has sent those documents along with a reply to the said notice also, my lord.
Yes.
Those documents, my lord, were seized through a mahazar also, my lord. That is a part of the charge sheet also. And, my lord, those documents were only sent to the certified handwriting expert, my lord, wherein the opinion of the expert says that, my lord, those signatures are forged one, And it is the accused number 1 who has forged those signatures of the complainant.
Yes.
And my lord, I would like to rely on the judgment of this honorable court, my lord. Recently, my lord, on the similar set of facts, my lord, on forgery, my lord. Paragraph number 10 and 11 would be relevant, my lord. It's at page number 9 of the judgment, my lord.
Yes.
An act or a fact would give rise to two circumstances, on setting civil law into motion and the other criminal law. Merely because the issue projected is civil, it is no law that this court, in exercise of its jurisdiction under section 482 of CRPC, should obliterate the crime. It is a matter of evidence which cannot be deciphered at this stage of the proceedings under section 482 of the CRPC. The apex court from time to time has held that merely because the issue projected appears to be civil, this court under section 482 of the CRPC cannot undertake a mini trial. That is the principle, my lord. Even on the facts, my lord, in that case also, my lord, the document was forged.
My lords, I'm not provided, my lords, a copy of the any.
Letter complete. I Thursday.
My lord,
Letter
the
complete.
counsel appearing for the other accused, my lord, he has produced two citations. My lord, I request my lords to kindly take those judgments, my lord, where he says that, my lord, he is only a witness to the document and hence the proceedings against him has to be quashed, my lord. My lord, he has relied on one judgment of the Supreme Court, M. Shrikant versus State of Telangana and another, my lord.
There is another. Citation. Accused number 2 has to. Good.
My lord, my submission is that, my lord, in those two cases, my lord, the accused were not signatory to the forged document, my lord. They were the signatories to the documents which were executed on the basis of the forged document, my lord.
Where is the facts stated?
My lord, in para number 7 of the judgment, my lord, in Shrikant versus State of Telangana and another.
Yes.
It is further the case of the complainant in the complaint that her brother, accused number 1, Akramuddin Hassan, who had falsely created a will in Urdu purported to be executed by their paternal grandmother, Karunissa Begum, in favor of their parents, Afzaluddin Hassan and so-and-so, for their lifetime and vested remainder to accused number 1. It is the case of the complainant that the said will is registered and said to have been executed on 2/4/1950. Further, it is the case that accused number 1 had also created another forged and fabricated document styled a deed of confirmation dated 8/3/1990, void which the property is orally gifted to accused number 1 on 29/8/1989 and also handed over physical possession thereof. It is further the case of the complainant that accused number 1, posing himself to be the owner of the premises on the basis of the alleged oral will and deed of confirmation, created a registered lease on 1/12/2008 bearing document number so-and-so, permitting accused number 4 to sublease the said land in favor of accused number 5. Accused 6 and 9 are the employees or officers of accused number 5, HPCL, whereas accused 7 and 8 are the attesting witness. They were the attesting witness to the lease deed, my lord, not to the will.
On the basis of the will.
On the basis of the forged document, my lord, they created the document.
Yes, on the basis of forged will. Yes. Yes, that is what she is saying.
In the other
His is not the
judgment,
forged document. Will is the forged document. Yes.
my lord, in the other judgment, my lord, criminal petition number 100659 of 2023 also, my lord. If my lord kindly consider page number 3 of the judgment, para number 4, where the facts are stated, my lord.
Yes.
A learned counsel Srimati so-and-so appearing for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that all the allegations of the complainant is against accused number 1, as the complainant and accused number 1 are relatives. The petitioner accused number 2 is neither the beneficiary of any alleged fraud, nor is the person who has purchased the property on the strength of the alleged GPA. GPA was the forged one in this case, my lord. She would submit that the petitioner is only an attesting witness. All the allegations are against accused number 1 and nothing against accused number 2. Therefore, she would seek quashment of the entire proceedings against the petitioner accused number 2. And para number 7 also, my lord, in page number 4. The aforenarrated facts are not in dispute. The private complaint is registered by the second respondent alleging forgery of a GPA and its benefit being taken by accused number 1. The averment in the complaint is that accused number 1 to 3 are friends and they are known to the complainant as well. While accused number 1 gets all the benefits, accused number 2 and 3 have been in active support of the acts of accused number 1. The benefit of the forgery is the sale deed. That is not the forged document, my lord. The sale deed is also appended to the petition. The perusal at the sale deed would indicate that the petitioner is an attesting witness to the sale deed. The forged document was GPA in this case, my lord.
Yes.
Hence, my lord, the honorable courts have quashed the proceedings. And these judgments are not at all relevant to this particular case, my lord. My lord, consider the Transfer of Property Act, my lord, the section 3, where it defines the attested meaning, my lord.
Yes.
Read, my lord.
Meaning of attestation.
Attested in relation to an instrument means and shall be deemed always to have meant attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument or has seen some other person sign the instrument in the presence and by the direction of the executant or has received from the executant a personal acknowledgement of his signature or mark or of a signature of such other person, and each of whom has signed the instrument in the presence of the executant. But it shall not be necessary that more than one of such witnesses shall have been present at the same time, and no particular form of attestation shall be necessary. My lord, this shows that, my lord, the attesting witnesses must have seen the executant signing or must have proper knowledge that, my lord, it is only the same person who has signed the document, my lord. Hence, my lord, the petition is required to be dismissed.
Kindly, my lords. In fact, my lord, my learned friend, she started from the middle. My lord, the contention by the other side is that both proceedings can go on. My lord, for a moment, my lords, probably the other side is forgetting that except filing, my lords, or initiating criminal proceedings, the second respondent, my lords, have not filed any, my lords, proceedings in respect of those documents either seeking for declaration as not genuine or anything. My lords, I'll show.
That is not the question.
Not, my lords, by the second respondent, by, my lord, the school, which in fact makes allegations against the second respondent, saying that he was no longer a
The
director.
matter is pending before civil court.
That is right, my lord. My lord, my respectful submission is that, my lords, the distinction is there insofar as, my lords, cases arising out of commercial transactions, mercantile transactions, to that of, my lords, other civil cases.
Yes.
My lords, this issue, my lords, is considered by, my lords, the Honorable Supreme Court in a latest judgment. In 2021, my lord, the SEC Online SC 1007.
second tab. That's it.
Your lords may kindly have my lords para 15, my lords.
What are the facts of the case?
My lords, if I'm permitted, my lords, para 2. The respond number, if your lordships are having.
Yes.
Respond number 2, Nazib Singh, the complainant, moved an application dated 18/8/2009 addressed to the Senior Superintendent of Police District Fatehgarh Sahib, stating therein that he was known to one Gurmeet Singh, who was in the business of sending people abroad. Gurmeet Singh had assured the complainant that his two acquaintances, Jaswant Singh and Gurpreet Singh, who are already settled in Italy, would help his son to get a job and settle in Italy. For the aforesaid arrangement, Gurmeet Singh demanded total amount of rupees 7 lakhs. Further, according to the complainant, rupees 4 lakhs was paid in cash on 10/12/2008, and thereafter rupees 2 lakhs were paid by way of a check dated 18/2/2009 of the Punjab National Bank branch, AS College, so-and-so, in favor of Gurmeet Singh, which amounts that since been credited in the account of Gurmeet Singh. Soon after, Sarpreet Singh, son of the complainant, was put on flight to Italy on 19/2/2009. Further allegation is that Jaswant Singh and Gurpreet Singh did not honor the promise and harassed his son. They did not arrange for a job and as per their promise. The documents were misplaced by them and ultimately his son had to return after 3 or 4 months. The complaint further alleges that the names of the accused further demanded rupees 3 lakhs and also threatened of dire consequences in case the money was not paid. That is, his son was mentally upset and he has also spent huge amount in traveling and thereafter and treatment of his son. It is thus prayed that the appropriate action be taken and justice be done. Lords, was the allegation. My lords,
Is relevant.
I'm not sorry, but the law, my lords, on the point of quashing.
It's not a question, it is not a case of
It's not-
forgery.
My lords, that's the reason, my lords, if lordships are kindly bear with me for a moment. My lords, the entire law, my lords, on this issue, my lords,
This
please.
is applicable.
my lords, my lords, the other judgments of this honorable court, my lords, which were considered by my lords, the honorable Supreme Court, during my lords, the hearing and disposing of this petition. Para 15, my lords. 15 would read, my lords. The power under section 482 CRPC is to be exercised to prevent the abuse of process of any court and also to secure ends of justice. This court time and again has laid emphasis that inherent powers should be exercised in a given and deserving case where the court is satisfied that the exercise of such power would either prevent abuse of such power or such exercise would result in securing the ends of justice. In this case, in the case of SW Palantikar versus State of Bihar, in paragraph 27 of the report, he has laid similar emphasis. The same is reproduced as under para 27. Whereas, while exercising power under section 482 CRPC, the High Court has to look at the object and purpose for which the power is conferred on it under the said provision. Exercise of inherent power is available to the High Court to give effect to any order under CRPC or to prevent abuse and process of any court or otherwise to secure ends of justice. This being the position, exercise of power under section 482 should be consistent with the scope and ambit of the same in the light of the decisions aforementioned. In appropriate cases, to prevent judicial process from being an instrument of oppression or harassment in the hands of frustrated or vindictive litigants, exercise of inherent power is not only desirable, but necessary also, so that the judicial forum of court may not be allowed to be utilized for any oblique motive.
Yes, that is all
My lord.
well settled, sir.
Yes, my lords.
Subject of 482 is very well settled.
Para 17, my lords. If it starts with my lord, 3 judge bench of this court in Gyan Singh versus State of Punjab again summarize the legal position which emerged.
Again 482 ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ
Principles
ಏನ್ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಇದೆ
482.
ಅಂತ regarding powers of High Court in quashing criminal proceedings in excess of power under section 482 CRPC. Speaking for the bench, clearly observed in paragraph 61 of the report that a criminal case is having overwhelmingly and predominantly civil flavor stand on a different footing for the purpose of quashing, particularly the offences arising from a commercial, financial, mercantile, civil partnership or such like transaction,
Yes.
or of the offences arising out of matrimony relating dowry, etc., or the family dispute where the wrong is basically private or personal in nature, and the parties have resolved the entire dispute. The relevant extract from so is produced as below. The position that emerges from the above discussion can be summarized that the power of High Court in quashing criminal proceedings or FIR complaint in an excess of its inherent jurisdiction is distinct and different from the power given to criminal court for compounding of the offence under section 320 of the code. Inherent power is of wide plenitude with no statutory limitation.
Yes,
But it
sir,
has,
that is all
my
well
lords, I
said,
mean,
well said.
according to me, my lord, the commercial, my lords, cases stands on a different footing.
Yes.
My lord, the decisions what my learned friend, my lords, relied upon. None of them, my lords, relates to this issue. My lords, the decision in 2002 8 SCC, my lords, what my learned friend relies upon in KG Prem Shankar versus Inspector of Police and another. My lord, that is, my lords, where an offence was registered under section 220 ATA IPC and section 7(1)D of the Protection of Civil Rights Act. Para 3, my lords, of the judgment. My lords, the decision, my lords, in criminal petition 5522 of 2024, my lord, it is in respect of a will, my lord, not a transaction, my lords, of the present nature. My lords, the other decision, my lords, in ILR 2017 Karnataka.
Yes.
My lords, it's a matter, my lords, where, if I am permitted, my lords, there was a civil suit filed by the individual who alleges, my lords, that there was some irregularity and also initiation of criminal proceedings. Unlike in this case, my lords, my lords, except complaining to the police, nothing has been done. My lord, my lord, set the records straight. My lord, the suit which is filed by Alliance Public School, my lord, business school, if I'm permitted to pass on, my lord, the copy of the plaint. Idya. OS 25382. My lords, I'll just read and pass it on, my lords. The allegation, my lords, where, my lords, these villains, my lords, Alliance Business School was the plaintiff along with others, and my lord, both the complainants were defendants 1 and 2. The allegations, my lords, are such that, my lords, if I'm permitted to read.
Where is that?
Para
Copy.
28, my lords, I'll read and my lords, pass it on. Para 28 reads, my lords, that the plaintiff submits that the first defendant, even after resigned as the managing director from the company, tried to manipulate documents, started acting like the managing director of the company. My lords, Madhukurangur, my lords, was the first respondent there. He did not update the names of additional directors, the second, third plaintiff hearing on the website of so-and-so. In the meantime, due to the interference and fake assurance given by defendants 2 to 6 and his current company secretary, the first defendant continued his illegal activities. My lord, the specific allegation is there is a resignation. In spite of that, my lords, he is trying to, my lord, push forward. My lords, this is in the year 2015 when, my lord, they say the incident occurred. That is 25382 of 2015. Para 28 minutes. Para 28. If lordships kindly see, my lords, the date, my lords, when the my lords, plaint was verified. Plaint, my lords, was verified on 17/4/2015. Lord, the complaint, if your lordships kindly see, or rather, my lords, the further statement, my lords, given by, my lords, the complainant before the police is that, my lords, I tried to, my lords, implead and they got the documents there. The specific allegation, my lords, of the complainant, if your lordships kindly see, my lords, the statement made, my lords, at
What is the date of complaint?
my lords, in our case, my lord, the complaint was filed
25/2015. 20/5/2015.
2000?
ಹದಿನೈದು ಮೇ ತಿಂಗಳು ಅವ್ರ ಪ್ರಕಾರ ಏಪ್ರಿಲ್ ತಿಂಗಳಿಗೆ he was not there.
Yes.
But that is the allegation that they disown my lords the complainant. The Alliance Business School says I have no connection with him and he is manipulating the records. My lords, your lordships can have my lords.
Suit has been withdrawn already.
One minute.
This suit
As on that time. If your lordships kindly see my lord, the
withdrawn on?
Not aware of the date, my lord.
Huh?
Give my synopsis.
Withdrawn
my
on?
lord, my lords, my lord, it is suit between them, my lords, the Alliance Business School and my lords.
You are not a
the-
party?
My lords, I tried to intervene, filed an application for impleading. And on that, my lords, that was taken by the my lords police and I am booked. My lords,
After you filed the suit?
my lords, in fact, my lords, I filed a complaint, my lords, as I came to know that, my lords,
Suit pending is filed by you?
my lords, that is after, my lords, the company law board, my lords, says I should go back. I filed, my lords, an
That
appeal
is
before this
number,
court.
OS number?
3243 of 2017. 3243 of 2017.
By accused number 1,
Yes, my lords. I have produced, my lord, the,
against both the complainants.
yes, my lords. In fact, my lords, both complaints were parties before the company law board, before this honorable court. The matter went to the honorable
What
Supreme
is
Court.
the stage of this suit?
At the stage of evidence, my lords, I'm
Plaintiff's evidence,
plaintiff's evidence.
not at lead.
Yet to commence.
No, issues are framed and my lords, is set for evidence.
Yes.
In fact, my lords, for a moment, if your lordships kindly see the order which I was reading to my lords, the order of this honorable court, division bench of this honorable court, about my lord, the pending criminal proceedings and my lord, the civil proceedings. In fact, makes a reference, my lords, to the suit also, which I just referred. If your lordships kindly have, my lords,
Maybe, but that suit is not pending now.
my lords, may not be, my lords, for the reason that, my lords, there was, my lords, water has flown. My lords, the person, my lords, went out. My lords, got involved in other criminal cases. My lord,
The division bench of this court considered the facts. The suit was pending. Not now.
no. This, my lord, the issue was that I contested the order where I was asked to go to civil court by the company law board.
Yes.
On that, my lords, while considering the fact that, my lord, criminal cases are pending, the division bench of this honorable court said that I have to go and, my lords, prosecute the civil suit, which will have greater importance and implications.
That
My lord,
is why
that's-
you filed 3243.
Yes, in fact, my lord, I went to honorable Supreme Court. My lord, the honorable Supreme Court also, my lords, was pleased to reject. Then, my lords, I filed the suit. Lords, in respect of, my lords, the question, my lords, whether he was competent to execute, my lords, any such agreement, my lords, what was actually, my lords, suppressed, and he is being suppressed.
Yes.
Is, my lords, the same order, my lords, which your lordships are having, my lord, the order of the division bench. In paragraph 46, my lord.
Already you have read it.
No, paragraph 46, my lords.
So in installment you are reading
No, my lords. In fact, my lords, there was a query put forth.
the document, you should read.
My lords,
There are
in fact, my lord, there was a query put up, my lords, to the other side about, my lord, the contention of pending civil and criminal. My lords, now the question is whether, my lords, he is competent to, my lords, do it or not. Paragraph 46, my lords, I'll read, my lords, and my lords, I'll stop reading this document. Paragraph 46.
Again, I have to search that.
No, I'm extremely sorry. What,
Very
my lords, I'll just, my lords, submit. What has been held by the court, my lords, when it was pointed out that he is also, my lords, working as the chancellor, and he should not have carried on the work. My lord, considering the submissions made by the complainant, my lords, before this honorable court, the division bench said there is an order to the effect that he will not cause any hindrance to the running of the school. But as a vice chancellor, he can do so because there is no such restriction is what the order is. That means to say there was the issue of an order being there against him was in his notice.
Yes. In this
No.
case, the stay was there.
Yes, my lord.
interim stay
Further
was there.
investigation will stay.
Yes, my lords. In fact, my lords, in my case,
Application has not been undertaken.
no, charge sheet
Charge
is
sheet
fine.
was
Cognizance.
filed.
Charge sheet is filed.
Under
Further
section
stay of the
173 subclause 8, my lord, they wanted to further investigate.
And my lords,
The charge sheet and the further investigation has stayed.
my lords, it is stated by the other side. It's as a school, like my lord, transferring a property, my lords, that they say there was an agreement by which it was claimed that the property can be, or the shares were transferred and all that.
Yes.
My lord, section 56, my lords, of the Companies Act, my lords, if I'm permitted. The execution by itself will not be sufficient, my lords, to say that there is transfer of shares. If your lordships kindly take note, section 30.
That is the position of law. Now the allegation is that you have forged that document.
Yes, my lords, that what I'm trying to say, my lords, if at all it was the allegation, nothing prevented, my lords, him from, my lords, pointing out to the company which has issued the share.
Yes.
Because the provision clearly says it is for the company to do it, not for the individual. Now, his case is that, my lords, he receives the letter which is addressed to the company. No, my lords, under what capacity? Section 56, my lords, of the Companies Act. 56(1), my lords.
What is the effect of the document is we are not concerned whether the contention of
No.
the complainant that it
Yes,
was
ma'am.
forged document or not. It is
What,
only to be
what I'm
considered.
trying to point out is that, my lords,
Effect under law,
yes, ma'am.
it is for the civil court or for the.
Yes, my lords. My lords, there is no difficulty. But what I'm trying to say is that, my lord, the person who had all these safeguards, my lords, representing to the company, saying that these documents were not initiated by him, or going to appropriate court or forum, seeking for such relief, nothing he has done except filing a complaint. Now, my lords, the other contention, my lords, which I have taken and which I have pointed out from the charge sheet also, and in fact, my learned friend also said, a certified lords handwriting expert was asked to give the opinion, and my lords, it was considered, and on that basis, my lord, the case is registered. If I'm permitted, my lord, the issue of, my lords, or rather the effect of the private handwriting experts giving opinion and launching, my lords, criminal prosecution on the strength of such, my lords, issue.
Cannot hold a trial, mini trial here.
No, my lords,
Holding a trial here.
my lord, the very,
These contentions you have to urge before this criminal.
that,
court,
my
not
lords, I
before-
understand. What I'm trying to say is that, my lords, what forms the basis? Ultimately, my lords, what is going to happen in the my lords, criminal proceedings? Ultimately, if it is going to end in acquittal, or, my lords, it is going, the entire proceedings is going to fall for some reason. My lords, why I should be, my lords, my lords, dragged in? My lords, in the interest of justice, my lords, whether it is justified, my lords, in allowing the criminal proceedings to go on. My lords, is the issue, my lords, according to me, requires some consideration. My lord, this honorable court, my lords, had considered, my lords, the issue of sending, my lords, to private handwriting experts in criminal petition number 100822 of 2016, if I'm permitted, my lords. That for that limited purpose, my lords, I'm to say that, my lords, nothing can be achieved
I
because
have to give a finding on that now.
no, what I'm trying to say is, my lords,
Sir, that is all outside the scope of 482.
my lords, according to me, my lords, the 482,
Go
my lords, the powers are exercisable under circumstances where, my lords, conclusion, my lords, is known. What happens, my lords, ultimately is known.
To say.
Why I should, my lords, in that,
The effect of these document share purchase agreement, whether in the eye of law, whether. it
no,
could
no,
be-
my lord, what I'm trying to say is
What
whether
is the
criminal,
effect of a report submitted by a private scientific officer?
whether the question is whether criminal proceedings can be initiated on the basis of a report submitted by a
That
private.
was not initiated on the basis of that report. After initiating criminal proceedings, the disputed document was referred to the scientific
Yes.
officer for his report.
The
And the report is
my lord,
received.
the
Charge sheet is filed.
yes, my lord, charge
Yes.
sheet is filed.
It
Charge
makes
sheet
all
is
the
also, my lords,
difference.
if your lordships kindly see, my lord, the summary, my lords, of the charge sheet. my lords, if your lordships are having, my lords, 7789. Page number 51. They say, my lords, that the matter was referred and my lords, report was considered. And my lords, the basis of allegation is that false, my lords, statements are made, for signatures were forged. My lords, ultimately to say that the signature is forged, it has to be, my lords, based on something. That is, my lords, what I'm trying to submit. That based on, my lords, the report of a private, my lords, expert, which according to the orders of the Honorable Court is not proper.
Yes.
Now, if considering that, my lords, let's assume that, my lord, the trial proceeds. Ultimately, my lord, the trial, my lords, is going to fall for the reason that, my lord, it cannot happen because of, my lord, the view taken by this Honorable Court. It cannot, my lords, continue any further. My lords, and my lords, I'll just read, my lords, a paragraph from the order of, my lords, the learned single judge, my lords, where, my lords, he also proceeds to observe that, my lords, circulars are also to be issued to ensure that there is no such thing resorted to by the investigating officers. My lords, para 7, my lords, I'll just read and, my lords, leave it at that.
Read it.
My lords, with aforesaid observations, this petition is disposed of. While resting with this matter, a direction is issued to the Home Secretary for issuing a circular to all the police stations. In the first place, directing them to conduct the investigation strictly in accordance with law and not to deviate from the procedure. Secondly, in cases where the investigations are taken up with reference to documents said to be forged and are fake documents, and the same are referred to private laboratories for verification, which is not correct. Therefore, when it comes to referring the documents for scientific verification, with reference to handwriting, signature, or age of the writing in the document, the same shall be referred to forensic laboratory of the state and should not be sent to private laboratory for securing their opinion. This is to prevent the possible manipulation in securing favorable reports and to manipulate the final report to be filed in the investigations. On that basis, my lords, now the state has also, my lords, issued the circular.
Yes.
My lords, that is the position of, my lords, as on today. No, my lords, I made a submission, my lords, that the very, my lords, this complainant, my lords, he is in the habit of, my lords, making similar complaint, my lords, to against all the individuals. I have produced, my lords, the copies of those complaints also, where he says documents were stolen, documents were snatched. My lords, in different complaints, my lords, ultimately he says share certificates were stolen, share certificates were snatched from me. My lords, he makes allegations, my lords, even against his brother, and my lords, against the other directors, and thereafter, my lords, against me. My lord, the issue is, my lords, he is a habitual complaint making, my lord, similar sort of allegations. My lord, that is, my lords, also one of the contentions. My lord, I made a submission that, my lords, independently the first, my lord, the accused, the petitioner, has preferred a complaint. And, my lord, that complaint, my lord, is considered. What forms the basis, my lords, for coming to a conclusion for filing final report, my lords, in respect of the complaints filed by the complainants herein is, or rather the report, the documents which are produced by me, my lords, during the course of investigation, my lords, in the other connected case that is filed by me. That, my lords, B report is filed. My lords, B report is contested. Now, my lords, the cognizance is taken, my lords, by the competent court.
Yes.
My lord, there is a, my lords, a case which is instituted by me, my lords, is also being, my lord, considered by, my lords, the lower court. My lord, my submission, my lords, in respect of these issues are concerned. The proceedings, my lords, I am seeking for quashing of these proceedings, my lords, primarily on the reason that, my lords, as your lordships rightly observed, that there is a civil case, my lords, which is pending, and the issue requires to be adjudicated there. The other contention which I have taken, my lords, is about the abuse of process by the individual.
Yes.
Now, my lords, to prevent abuse of process, this honorable court, my lords, according to me, my lords, can definitely intervene, and my lords, can issue, my lords, the appropriate directions.
Yes.
My lords, insofar as on these grounds, my lords, I have approached this honorable court. My lords, if there is anything, my lords, from the other side, my lords, I seek, my lord, liberty to, my lords, reply to that.
Only a short submission was from the respondent company. My learned friend has mentioned various civil disputes. Not those civil disputes are between me
For respondent number
and for
two.
the respondent 1 and 2. Sorry, two minutes, sorry. With respect to those disputes are with respect to me and the other directors in the company, who are none other than my siblings. But the matters are going on where we are fighting with respect to the title of the dispute, control of the university and control of the company. He has nothing to do with that. Now, merely because he has filed a civil suit, that will not absolve him from the forgery or fraud that he has committed. Now, these courts have already, not the Honorable Appeals Court and this court has already distinguished when civil proceedings, where color of criminal proceedings will be made and when it will not be, it has been already distinguished. In the case of forgery, where even when we are saying, Lord, it is not my case that he induced me to enter into this agreement. It is my case that he has forged my signatures on the share purchase agreement, on the memorandum of understanding. And the witnesses who have said they have executed, they have witnessed the signatures, so they are also part of this criminal proceedings, and therefore, after due investigation and after obtaining the opinion from the scientific laboratory, the charge sheet has been filed against everyone. This is one thing. Second submission, where my learned friend produced the judgment saying that it cannot be sent to the private laboratories. And the circular was issued in the year 2017. The charge sheet has been filed much before that, 2 years before. In this case, it has been filed in 2015 itself. So therefore, that is not applicable to this present case.
Yes.
Now, because in 8938, the petitioner has filed a memo with respect to list of cases, saying that these are the civil disputes, pending disputes, and all those things.
Yes.
Other than 3243, which has been filed by my learned friend, who is accused number 1. In none of the matters, neither is a party to it, nor in many matters, I am not a party to it. Lord, in first matter A 175, it has been mentioned, it has been issues, it has been already.
So we are not concerned about that, sir. Why should we bother about that?
Yes, ma'am.
There may be hundreds of cases.
There are many disputes. What he is concerned is only about in that serial number 5, where he has filed OS 3243 of 2017. Now, merely because he has filed a civil case, that will not absolve him from fraud. That is all. That's my submission.
Yes.
The benefit that is being derived to these personal cases, that is not. The target being 420, 425.
Yes.
Now, all the submissions have been already made. Now, what is the benefit? Rather is that all those things, only the trial will.
Point of that I am not paying benefit or not either inducement and 420 and second not that I am not a part of the whole job you start in the point of not both two things are not applicable to the
Yes.
second, so the judgments are produced, not the Supreme Court judgment, actually, Srikant will state, but what happens then is based on that particular court will, the other document is created. The creation of another, these three documents, at paragraph 14 and at paragraph 19. As we said, what is read below is the initial paragraph at paragraph 14, but the also Supreme Court is looking further and say, it is the creation of these subsequent leasing based on the creation of the second document also is there. So when they issue below of Forgery, it not only to the bill, but also the subsequent leasing. And this conclusion was not considering, has mentioned about Srikant and other judgments, where a series of the judgments were taken by the court, of Chhattisgarh High Court, of UP Allahabad High Court, there is a judgment at file number 19. Not consider similar situation where the persons who are not attended witnesses and referring to that basically under section 3 of Transfer of Property Act, not as considered. And not based on the reliance, not on that, not on the report, not on the report.
Yes.
Not that, I think those are not against
Just as a, my lords, one rebuttal, my lords, insofar as the submission made by the other side is that except one proceedings, my lords, others are not related to, my lords, us. My lord, fact remains that, my lord, the order of the division bench, which I, my lord, cited, involves all three of us. A specific finding is made, my lord, about, my lords, the pending criminal case and, my lords, the civil proceedings to be launched. And, my lord, this honorable court, my lords, being, my lords, responsive submission is that, my lords, being an order of the division bench, my lords, to an extent, my lords, according to my lord, it would bind, my lords, this honorable court also. My lords, as such, my lords, where we were parties there, my lords, it cannot be said that, my lords, merely for the reason that he makes an allegation that the proceeding should go on. And, my lords, as, my lord, my lords, the civil court can take, my lords, a different view. No purpose would be served, my lords, in my lords, going further with this prosecution, my lords, is my submission.
Next month, there again. These two. These two. These. Handwritten notes again. Yes. Reserved.
One submission, my lords, the interim order may be continued, my lords. Ultimate, my lords.
In a day or two, it will be
Oh, then obliged. No, no,
obliged.
please.
Next.
Order,
ಅದನ್ನ ಕಳಿಸ್ಬಿಡಿ ಬರೋ.
for order, serial number 3, Shaman Ahmad Patel, Jay Prakash.
My lord, I filed wakalat for R2. And ಅವರು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕಿದಾರಂತೆ. They said they will file retirement.
R2.
R2.
Who was appearing earlier?
ಅವರು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಅರ್ಲಿಯರ್ ಹಾಕಿದ್ದಾರೆ.
So and so. Muzaffar Ahmad, Learned Counsel for respondent number 2 filed a memo seeking permission to retire. In the meantime, Shri Jay Prakash India, Learned Counsel, has filed wakalat with MOC. Hence, the earlier counsel Muzaffar Ahmad is permitted to retire. Office is directed to delete his name in the cause list and show the name of so and so.
Please.
Then yes.
Well, Lordship, the petitioners are the in-laws of the complainant, Your Lordship. Petitioners are the in-laws of the complainant, Your Lordship.
How many? 2 petitioners, huh?
5 petitioners are there, Your Lordship.
There are
Accused number
5.
2 to 6.
There are
Accused
5
number-
petitioners. Who are the in-laws?
The petition number 1 is the brother, Your Lordship. Petition number 1, 2, 3 are the brothers. 5th one is the sister, and 4th one is the wife of the brother, Your Lordship. That is Muhammad Waris, petitioner number 1.
Petition numbers 1 to 3 are the brothers.
Yes, your lordship.
of accused number 1.
Yes, your lordship.
Then what about
Petitioner number 4 is the wife of the petitioner number 1.
then 6, 5?
And 5 is the sister of the accused number 1.
Whatever the offense alleged.
Offense is 498A, 34 and of IPC and section 3 and 4 of Dowry Provision Act, your lordship. Marriage of Salama is on 31/3/2011, your lordship.
Yes.
The marriage was love marriage, your lordship, after courtship of 6 to 7 years, your lordship.
The
Your lordship.
investigation charge sheet is also filed.
Charge sheet is also filed, your lordship. There is no allegation against me, your lordship, in the complaint and in the charge sheet. Your lordship may kindly be see the page number 9.
Date of complaint?
26/8/2014.
2014, your lordship. May I read, your lordship? ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ
What is that you are reading? You
Complaint.
read the charge sheet, column number 7.
it is in page number 16, your lordship.
Yes.
It contains the allegations against me. ಎರಡ್ ಸಾವಿರದ 13ನೇ ಸಾಲಿನಲ್ಲಿ A1 ಆರೋಪಿಗೆ ಮದುವೆ ಮಾಡಲು ಬೇರೊಂದು ಹುಡುಗಿಯನ್ನು ಹುಡುಕುತ್ತಿರುವ ವಿಷಯ ತಿಳಿದು ಸಾಕ್ಷಿ 1 ರವರ ಆರೋಪಿತರ ಮನೆಯ ಹತ್ತಿರ ಹೋಗಿ ವಿಚಾರ ಮಾಡಲಾಗಿ A2 ರಿಂದ A4 ವರೆಗಿನ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಸೇರಿಕೊಂಡು ಆರೋಪಿ 1 ರವರಿಗೆ ನಿನ್ನ ಗಂಡವನ್ನು ಮರೆತು ಬಿಡು, ನಿನ್ನ ಗುಣನಡತೆ ಸರಿ ಇಲ್ಲ, ನಿನ್ನ ಪಾಡಿಗೆ ನೀ ಬದುಕೋ, ನೀ ನಮ್ಮ ಮನೆಗೆ ಬರಬೇಡವೆಂದು ಅವ್ಯಾಚ ಶಬ್ದಗಳಿಂದ ಬೈದು ಜಗಳ ತೆಗೆದು A1 ರವರಿಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಹಿಂಸೆ ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಹಿಂಸೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಓನ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಅಗೇನ್ ಮೀ. There is no date, your lordship. There is no time. There is no specific allegations, and the purpose for which she has gone is not clear, your lordship. Moreover, the FIR is filed at the fag end of the 2014, your lordship. Whereas, as per her, this one complaint. There is no absolute.
Yes. What is it?
I may require a day's time because I've not received the file yet, just the NOC.
ಆಯ್ತು, ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, you can look
Then I
it.
was just trying to have a glance.
Now he has read the part of charge sheet. That
Please.
is the only allegation against accused number 2 to 6.
That is the.
2013.
Please.
When the complainant had gone near the house of accused number 2 to 6, they have abused her. ನೀವು ಮರೆತು ಬಿಡು, ಗುಣ ನಡತೆ ಸರಿ ಇಲ್ಲ, ನಿನ್ ಪಾಡ್ನಿ ಬದುಕೋ, ಇಲ್ಲಿಗೆ ಬರಬೇಡ ಅಂತ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದ್ರು.
My handicap is
What
that
offense it
I
constitutes?
got only the NOC wakalat because that
ಈಗ ಹೇಳಿದ್ನಲ್ಲ, ಹೇಳಿದ್ನಲ್ಲ.
I understand. Madam.
Yes, what do you say? You-
Yes, my lord, there is an allegation against accused number 2 to 6 of physical and mental harassment as your lords just pointed out, my lords. There
What
is
is
the
the
only
physical
allegation.
harassment?
ನಮ್ ಮನೆಗೆ ಬರ್ಬೇಡ ಅಂತ ಅನ್ಬಿಟ್ಟು ಮನೆಯಿಂದ ಹೊರಗಡೆ ತಳ್ಳಿರಬಹುದು.
They abused her.
Yes,
Don't
ma'am.
come to our house.
ಮನೆಗೆ ಬರಬೇಡ, ನಿನ್ನ ಜೀವನವನ್ನು ನೀನ್ ನೋಡ್ಕೋ, ನಿನ್ನ ಪಾಡಿಗೆ ನೀನು ಬದುಕು.
The husband is in Saudi. He
Yes,
is
ma'am.
not in staying in that house.
Yes, my lords.
Naturally, they said, ನಮ್ ಮನೆಗ್ ಬರಬೇಡ, ನೀವೇನಾದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ.
Where should she go, my lords? It is her matrimonial house, my
She
lords.
has to go with the husband.
That is what, my lords, one of the allegation against these accused are, he left India without intimating the victim, my lords. That is also an allegation.
She, husband might have left her.
Yes,
But
ma'am.
what the brother-in-law, sister-in-law, they have to do.
In,
They have to look after.
my
her.
lords, section 120 has not been invoked, my lords. By doing conspiracy, they might have sent the accused number 1 to
Not
abroad,
the
my lords.
contention.
Yes, my lords.
When she had gone near their house, they said, ನಮ್ಮ ಮನೆಗೆ ಬರಬೇಡ, ನಿನ್ ಜೀವನ ನೀನ್ ನೋಡ್ಕೋ.
That is the only allegation
all.
that has
One
been.
request, madam. It will be called day after tomorrow. I
ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಂತದಿಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟು.
file my formals just because I have appeared.
ಅವ್ರಿಗೆ ಕೊಡ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಡ್ರಿ.
Yes, my lord.
I will take the
Read
copy,
it.
my lord. I'll
ಅಲ್ಲಿ
make some,
ಬೇರೆ ಒಂದೇ ಒಂದ್ ಶಬ್ದ ಇಲ್ಲ.
let there be a responsible
Allegations
submission.
against accused number 1 is very serious, yes.
I'll make
Not
a
against these family members. They are
Lord is
brothers, brother-in-law, sister-in-law.
My lord is inclined to quash the whole proceedings or only against the relatives, my lord?
Hmm?
Only against the relatives, my lord,
Yes,
The present.
not against the
petitioners.
husband.
The present
Husband,
petition
there is allegations.
Accused number 2 to 6 only. Accused number 1 is
petitioners are
not
the
petitioner.
brother-in-laws and sister-in-laws.
Yes, ma'am.
That though I may have to concur with my lord's,
Hmm?
I may have to concur with what my lord says. But as against husband, I have my reservations of
Yes.
quash.
You can proceed. Husband is not a petitioner.
No, my
He is
lord.
not.
Accused
He's
number
not a
2 to
petitioner.
6 are the.
I think I might not have
Yes.
that
I
serious
will
of an
take-
argument
I
on
will-
that. Maybe taken as seriously objected.
Yes, yes, as always.
Seriously. rejected.
So,
The petitioners being accused numbers 2 to 6 are seeking to quash the criminal proceedings initially against them in pending in CC 51020 of 2016 on the file of the learned 11th additional Chief Metropolitan Magistrate Bengaluru for the offense punishable under sections
this is common conduct. This is common.
498
Against joining other.
that is
members
section
of the
34
family
of IPC and under 3 and 4 of Body Prohibition Act. Brief facts of the case are that respondent number 2 has complainant filed the first information against accused number 1 to 6, alleging that she married accused number 1 on 31/3/2011
Oh, I can't point out all those things.
by paying the dowry as demanded. When she was residing in her matrimonial house, accused number 1 used to abuse her and treat her cruelly, both physically and mentally. Later, he went to Saudi Arabia, leaving the complainant in her parental house. The complainant came to know that accused number 1 is making effort to marry another girl. Immediately, he went near the house of accused number 2 to 6. And at that time, these petitioners, being the brothers and sister of accused number 1,
ಆಗಿದೆ.
abused her in filthy language, saying that she will not be permitted to enter their house and she has to lead her own life. After investigation, charge sheet is claimed to be filed for their petitioners are before this court seeking quashing of the criminal proceedings. Third so and so. Learned counsel for the petitioners contended that the petitioners are the relatives of accused number 1. Except saying that during 2013, when accused number 1 was in Saudi Arabia, the informant went near the house of accused number 2 to 6. They have stated that she will not be permitted to enter their house. And she has to lead her own life. There is absolutely no other allegations. The serious allegations are against accused number 1. merely saying that the informant will not be permitted to enter the house of accused number 2 to 6 will not amount to offense under section 498A or under section 3 and 4 of DPI. Separately, the complaint refers to the names of these petitioners simply because they are the brothers and sisters of accused number 1. The initiation of criminal proceedings is a clear abuse of process of law, and therefore pays for allowing the petition. Per contra, learned counsel for respondent number, learned additional SPP for respondent number 1, and learned counsel for respondent number 2, opposing the petition submitted that the informant specifically referred to the names of these petitioners in the first information and also referred to the incident that had taken place during 2013 when they have abused the informant in filthy language, prevented her from entering the matrimonial house, and also asked her to go away and to lead her life. Since prima facie materials, the prima facie case is made out on filing of the charge sheet, the case is not a fit, it is not a case fit for quashing the criminal proceedings, hence placed for dismissal of the petition. There is the point for consideration. My answer to the point is in the affirmative for the following reasons. The informant logged the first information on 26/8/2014, specifically contending that she married accused number 1 on 31/3/2011 by paying the dowry to accused number 1. Immediately after marriage, she went to matrimonial house and accused number 1 started abusing her that she is not good looking, nor she is having good behavior, etc. Later, he had gone to Saudi Arabia. Only during 2013, when the informant came to know that accused number 1 is looking for another girl for marrying, she went to the house of accused number 2 to 6, being the brothers and sisters of accused number 1, they said to have abused her, saying that she is not permitted to enter their house and that she has to lead her life. So, merely on these utterances, it cannot be said that either section 498A of IPC or section 3 and 4 of DP Act would be attractive. There is absolutely no prima facie materials against these petitioners to constitute any of these offences. The relationship of accused number 2 to 6 with accused number 1 is not in dispute, as it is stated that accused number 2 to 4 are the brothers. Accused number 6 is the sister of accused number 1, and accused number 5 is the wife of accused number 2. It appears that since they are the family members of accused number 1, they were also roped in by the informant. Continuation of criminal proceedings against them would definitely amount to abuse of process of law. The criminal proceedings against the petitioners is liable to be quashed. Accordingly, I answered the above point in the affirmative and proceed to pass the following. Petition allowed.
Obliged.
Serial number 4, Srinivas Murthy.
Yes, this dispute relates to a trademark. May I request Lordship to
Police
just
report.
see page 2, my lords.
Yes,
Police report.
Page 2.
Yes, my lord.
Await report.
My lords, I have to verify that, my lords. I need a short accommodation, my lords. I need to take instructions and with respect to the police report, my lords.
My lords,
Both the
what is
things.
happening in this matter? all the disputes have been settled before various courts. And this is one dispute that they are supposed to withdraw. In the sense FIR has to be quashed. They are not making any submissions before the court. May I request your lordship to kindly verify kindly look into the memo filed on 17th August 2018. In that memo, I have stated, my lord, there are five proceedings. On 2 occasions I filed. One is on 17th of August.
Copy could 17th of August.
One is 17th August. The other is 6. Yes. 12/6.
12/6.
Put it last time, put it.
Yes, it is.
We have furnished last time. I'll give one more copy also. Yes. And one is on 12/6. So there are, I have mentioned. Well, not got it.
Yes, got it.
This respond number 2 is the agent of Pinanki, Nancy Shah. Mr. Nancy and and Euro Ceramics. He lodged a complaint with respond number 3, who approached respond number 1 and
Notice is
eventually.
started served on respondent number 2. Still awaited. Let us await for.
My lords, what is happening, my lords? That gentleman, that respond number 2 has lodged a complaint with respond number 3. Respond number 3 has taken action against this, and he is not coming forward. He is not authorized. That is what I am saying. He is not authorized. There were 6 cases, my lords. May I request your lordship just
One. But respondent number 2 is to be served.
He's for last 6 years I've been trying. He's not coming forward. In fact, I requested the police people to say that let them take statement from him whether this dispute is still alive or it is no more. They are not doing that. They are harassing us.
As in the morning only, and this copy I have received just now, my lords. I have to go through the papers
I
and
have
I
given
will
all
make my
these papers to the
respectful
police.
submission, my lords.
In
A
fact,
short
all these
accommodation may be given, my lords.
I'm sorry. My lords,
When
there
the
are court
complaint-
orders.
When the complaint was filed.
Complaint was filed, my lord, on 29th. Yes, complaint was filed on 29th August 2017. Then I filed petition on 16/10/2017, my lords. Within 3 months, disputes have been settled. That is why I did not go the court. Kindly turn to this page number 2, my lords.
Any investigation was undertaken in this case?
They have seized the material. It is there, it is in their custody.
Charge sheet is not filed.
Hakilla. Charge sheet has not been
Any
filed.
interim order was in operation?
No, I did not press because all these days, because matter has been settled there in Bombay High Court. And I have kindly referred to page 2, my lords, just for a minute. Page 2 of my synopsis. He submitted that K. Harish Kumar of EPPIR, here not referred to as EPIR, in collusion and connivance with Pinanki.
Where you are reading?
I am reading page 2 of the synopsis because the entire case rests in this. Page 2.
Synopsis filed along with the petition.
Yes, my lords.
Yes.
Para 4 is, respond number 2 is the investigation agency. And the original complaint is registered at Batarayanpura Police Station, Bangalore, through respond number 3. Respond number 3 is informant who acted based upon the false and frivolous complaint of respond number 2. Respond number 2 is not before this court. He is not been served so far, 7 years. It is submitted that Mr. Harish Kumar, that is same respond number 2, in collusion and in connivance with Nancy Shah and Nancy L. Shah, director of Euro Ceramics, have resorted to script very vexatious complaints against petitioners 5 and 6, which had led to the filing of the present FIR. Pinanki and Shah, in connivance with respond number 2 and its company, have all scripted 5 false cases against respond number 5, petition number 5 and 6, herein for disputing for a dispute pertaining trademark, which is inherently a civil nature. It may be mentioned herein that complaint has been already filed against the petition number 1 to 4. The present FIR, which is the 6th one, is all the complaints, my lords. These are the complaints which have been filed. All these have been quashed. This kind reference is invited to the memo which I have filed long ago. But these are the all the cases which Your Lordship has just now seen is available in page document number 1, my lords. That is memo dated 17th of August 2018, my lords.
But
That
My
they
lords, we
make
have
an
to,
effort to serve respondent number 2.
my lords, and I have to,
Not serve any purpose.
I have no objection, my lord. I have no,
Will not serve any purpose if I hear you in this matter. Unless respondent number 2. is
I know, my lord. What is happening in this, my lord? Kindly turn to just a minute, my lord. Document number 1, my lord. Document number 1.
So
is
for what purpose?
the problem is like this, my lord.
To convince myself.
No.
Then-
What I am saying, there is an order, there is a consent agreement between the parties.
I will consider on merits.
Then, my lord, let them not interfere with our business now. Let them not do that.
All these days.
I have
they
filed an
not-
application.
All these days they have not.
ಇರ್ಲಿಲ್ಲ ಈಗ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Now they have started. When this court has called upon them to file report, they have started already.
my lords, we have to
Illi,
see,
my application, IA is pending, my lord. Till then, my lord,
my lords, we have to
I
see
number two,
whether
my lord.
he is referring
this is
to
what
the,
these people are saying here. IA number,
my lords, a kind submission, my lords, we need to see.
when the
whether
matter is
the
settled,
pres-
3 courts have said,
When
yes,
you
it has-
filed the application? When you filed the application?
October 2017. In the month of, I have produced the court
Yes,
orders.
Days you.
My lords, next week, my lords, next Monday, my lords.
But necessarily respondent number 2 is to be served.
Yes.
I'll look into it. Yes, my lords. And one more
So-
submission, my lords,
In a
as
minute.
the papers he has produced, we have to see whether it has been arisen out of the same transaction which he is alleging, my lords. I'll just
That's-
verify the papers.
On merits, it will be.
Yes,
considered.
Bombay High Court, Gujarat High Court, I produced all the orders.
See that respondent number 2 is served.
Yes, my lords, I'll do that. my lords.
In the meantime, my lord, let them not harass us. I have filed an application for stay.
In what sense?
In the sense, they'll call the petitioners to their office and I made them to sit there.
There is no.
And there's
proof,
so
my
many
lord,
things
no
they're
proof.
saying.
It's a false
Yes.
allegation, my lords. I'll verify,
An
my
affidavit
lords.
to that.
Is the investigating,
Yes, my lords. Just one.
learned counsel for the petitioner submits that respondent number 2 is the mischief monger who is behind the screen. And deliberately he is not appearing before this court. Next para. Learned HCCP, learned additional SPP, prays for time to get instructions regarding the status of service of notice on respondent number 2. She undertakes to instruct the investigating officer to serve respondent number 2 before next date of hearing. In the meantime, the next para. Then counsel for the petitioner submits that the investigating officer has started to interfere with the business of the petitioner without any basis. Without any basis. Then the additional SPP is directed to instruct the investigating officer not to precipitate the matter till next date of hearing. Please start.
Alerts action. Till next date, let them not do anything.
Yes, I have recorded.
Yes, ma'am. Yes, ma'am.
Number 5, YT Abhinay.
R5, my lord, is the complainant. The notice that is issued by this court to the address given in the complaints, my lord, shows that no such person.
Hmm.
But they will have to provide fresh address, or my lord, I'll maybe permitted to take through paper publication. I'll make a necessary application because 3 times not will let.
3 times already.
ಇದು ಈ ಸತಿ ಇನ್ನೊಂದ್ ಸತಿ ತಗೊಂಡ್ರೆ 3 times.
Only twice it has gone.
I'll take one more
Third
step.
time you have to pay.
I'll take it.
Pay it today.
I'll do it, Bandi.
Learned counsel for the petitioner undertakes to pay PF with correct address for issuance of notice to respondent number 5 during the course of the day. If PF is paid, issue notice. Next.
Great.
Government advocate.
I appear for the petitioner, my lord. My lord, I pay for a day's accommodation to pay the PF, my lord. Pay the PF.
And HCCP pays for time to pay PF for issuance of notice. PF with correct address for issuance of notice to respondent. Yes, next. 2016 matter,
Yes, my lord. I'll pay.
if PF is paid with correct address is furnished, issue notice. Next.
Serial number 7, same.
My lord, I make one submission in serial number 7, my lord.
Hmm.
My lord, in the year 2020, my lord, it is already served, my lord, by due to inadvertence, my lord, this report is not filed before this honorable court.
Now you file it.
Al adralilla, my lord, it is the,
You have to file it.
I'll file, my lord.
Yes, file with the memo. Pass
Yes,
over.
ma'am. It is already served, my lord. It is, the report
The
was,
report.
this is the report for having served it, my lord. It was dated in
file.
2020, my lord, but it was not produced at that particular time.
2020. Issued by the investigating officer
My lord, these are the matters, my lord.
for having served the notice on respondent number. Sole respondent.
Yes, ma'am.
The respondent. The report of the investigating officer is placed on record. Service to respondent is held sufficient. Respondent remained unrepresented. Yes, next.
My lord, the question of law in these matters are one and the same, my lord.
Hmm.
May be connected together, and I'll also give the numbers of other petitions of the same.
Yes. Then,
Maybe
so
connected
then
together, my
CP submits that. WP number so and so, so and so. Go to the
132.
Connected with the mail in the 6. It is connected with serial number 6.
Yes, my lord. 6 and 7 are connected, my lord, and I'll
Proceed,
give the
take.
other petition number.
While giving, you also include this serial number 7.
Yes, my lord. And the issue has been covered by the judgment of this honorable
Yes.
court itself, my lord. I'll produce that judgment
Office is
also.
directed to list all these cases together. Yes.
Oblige me.
In the meantime,
I'll
Pay
pay the
PF.
PF also, my lord.
yes.
Number 8, Ashok Tripathi.
Hmm. Counsel for the petitioner is absent, no representation. The order is dated 23/8/2023, reads as under. In spite of that, there is no progress in the matter. Hence petition against respondent number 2 stands dismissed. List for next date.
Serial number 9, disclosed 10
Next
1.
stage. ಏನು stage ನೋಡ್ಕೊಂಡು. Yes. Counsel for the petitioner is absent, no representation. Order sheet dated 30/7/2024 reads as under. In spite of that, there is no progress in the matter for issuance of notice to respondent number 2. Petition against respondent number 2 is dismissed. Next stage, give a short date code or to dismiss. Yes.
But 11,
8 and 10 ಒಟ್ಟಿಗೆ.
My lord, in this case, we have filed a B report in the year 2019 itself, my lord.
Same date.
In serial number 11, my lord, we have filed B report in 2019 itself, my lord.
Already filed.
Yes, my lord.
Yes.
My lords, on last date of hearing, I was directed to take hand summons, my lord, taken it, my lord.
It's
I
not
wasn't aware of the fact that B report has
You
been
will not be
filed.
aware because you will not find it. Don't expect the court to come into your house and tell it.
Apologies, my lords.
Counsel for the petitioner again plays for time. Learned HCGP submits that. The investigation is completed and B report is filed during
19, my lord.
19 itself.
17/12/2019.
17/12/2019.
Yes, ma'am.
Learned counsel for the petitioner is not aware of these facts. Petition dismissed as the same is rendered infructuous. Next.
serial number 12, Karnataka, E.N. Jagdish.
Learned counsel for the petitioner filed a memo Permission to withdraw the petition. The same is rendered infructuous. Memo is placed on record. Petition is dismissed as the same is rendered infructuous. The pending applications are also dismissed. Branch disposed of. Year 1 of 2022 is there. Yes, next. Next.
13, hearing on IA, K. Prasanna Shetty, K. C. Pradeep.
For the appellant, my lord.
For respondent two,
My lord, there is 17 days of delay in filing, my lord. The reason is in Lokayukta, the opinion transfers from branches to branches, so the delay has been done.
Yes,
For respondent two, my lord.
respondent number 2.
Yes, ma'am.
What about 1? You
Here
are
is
not
17
representing 1.
Yeah, condoned delay. Here is 17 days delay, madam.
Huh?
17 days delays.
Are you representing respondent number 1?
2.
Only 2, not respondent number 1. Nodi 1 yaar. Okay. ಆಯ್ತು ಮಾಡಿ. ಏನಿದೆ ಕ್ಲಿಯರ್ ಆಗಿ ಅಡ್ಮಿಟ್ ಆಗಿತ್ತಾ ಇಲ್ಲ ಅಂತ? ಅದಕ್ಕೆ ಬೇಲಿಗೆ ವಾರೆಂಟ್ ಕೊಟ್ಟಿದ್ದು. ಕರೆದಿದ್ರೆ ಅವರು ಹಣೆ ಬರೋದಕ್ಕೆ ಈ ಟೈಮಿಗೆ ಯಾಕೆ ಬೇಕು? ಅಪೀಲ್ ಹಲೋ ಆಗೋದಾದ್ರೆ ಅವ್ರನ್ನ ಕರೆಸ್ಬೇಕು. Respondent number 1 is absent, no representation. As per order dated 15/7/2024. Respondent number 1 was who was produced before the court by executing NBW was released on bail subject to conditions. Respondent number 1 had undertaken to engage the counsel within 10 days. But he fails to do so till date. Till date. Next, heard and counsel for the appellant and respondent number 1 on IA 1 of 2021, seeking condonation of delay of 17 days in preparing the appeal for the reasons stated in the application affidavit nodi. Affidavit nalla ಏನದು? Reasons stated in the application affidavit ನೋಡ್ಕೊಂಡು ಹಾಕಿ. IA 1 of 2021 is allowed. Delay of 17 days in preferring the appeal is condoned. List for admission. List for admission. IA is allowed. ಯಾವುದು? ಲೋಕಾಯುಕ್ತ ಇದ್ದಾರಾ? Respondent.
Number 14, Ganpati Bhattacharya.
In this case, my lord, that I have filed the amendment application for seeking amendment of the specific provision which my lord challenged in this writ petition. Kindly see, my lord, in page number 41. The petitioner has sought, my lord, earlier struck down section 376 of Criminal Procedure Code as unconstitutional. Now, my lord, by virtue of, my lord, new enactment, that is 417 has been in place of, my lord.
But for the pending applications, it will continue to apply.
But my specific prayer is, my lord, is struck down. Now, my lord, that provision is not there. Therefore, my lord, I am seeking this insertion of.
Yes, what do you say? No objection? Huh. No objection. ಏನು ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ ಕಂಟೆಸ್ಟಿಂಗ್ ಯಾರಿದ್ದಾರೆ?
Contest is central government. Other rest of the prayer is consequential prayer to, my lord, insofar as first prayer.
Other respondents.
State.
No objection?
Yes, ma'am.
Hold. Hold. Very good. Name the designation in CGC, Leonard CGC for respondent number 1. And that is CGP for respondent number 22.
4, my lord.
4. Submit no objection to allow IA 1 of 2024. Filed by learned counsel for the petitioner seeking permission to amend the writ petition. For the reasons stated in the application. Filed under Order 6 Rule 17, of CPC, Review Section 226 and 227 of Constitution of India. The application IA 1 of 2024 is allowed. Learned counsel for the petitioner is permitted to carry out the amendment in the petition.
I make one submission.
Yes.
So even that amendment is not necessary, we have section 531 of the new act.
Hmm.
So the new act 5.
Yes, savings.
Saving clause.
ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು. Yes, carry out the amendment.
Yeah, I'll get it.
Yes. Immediately carry out. ಅದಕ್ಕೆ
Yes.
ಮತ್ತೆ ಇನ್ನೊಂದು ದಿನ ಬೇಡ.
Next date, my lord.
ಮಾಡಿ.
ಈ-
First
ಈಗಲೇ-
carry out the amendment.
ಈಗಲೇ ಮಾಡ್ತೀನಿ.
Yes. List for admission. After carrying out the amendment, it will be listed for admission.
Date will be given,
Date ಆಮೇಲೆ ಕೊಡ್ತಾರೆ.
please.
Yes.
Date may be fixed, my lord. Any date may be.
Date ಕೊಡ್ತೀವಿ.
ಆಯ್ತು.
But please carry out the
Please,
amendment.
please.
ಅವ್ರು amendment ಮಾಡದೆ ಏನು date ಕೊಡ್ಬೇಡಿ. Yes.
Right.
Serial number 15, Union Adjudicative, Arvind Babu. Union Adjudicative.
ಕೊಡಿ.
Copy today only, my lord, they have given. Request my lord to take it next week. ಕೊಟ್ಟಿದ್ದಾರೆ copy.
ಈಗ ಅವ್ರದ್ದು ಮುಗೀತು, ನೀವು ಟೈಮ್ ಕೇಳಲಿಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರಾ?
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇ ಫೈನಲಿ ಇಂತ ಆಗಿದೆ ಇದು. ಮತ್ತೆ ಯಾಕೆ ನೀವು ಕೇಳ್ಬೇಕು?
ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ ಮಾಡಿ. ಈಗ ಬಂದಿದೆ ನಮ್ಗೆ.
Learned counsel for you are served with the copy.
Yes, my lord, sir.
Learned counsel for respondent number 1 and learned additional SPP for respondent number 2 acknowledges the receipt of the copies of the petition. Learned counsel for the petitioner is absent, no representation. Matter is listed finally, listed today to afford first opportunity for the petitioner to address the argument. In spite of that, there is no representation. We do not find any reason to adjourn the matter, however, to afford one more opportunity this time. Finally, next date of hearing, please be prepared. And yes.
KP Loknath.
Hearing for the petitioner. Last time 8/7/21 admit and stay ಆಗಿದೆ sir.
ಆಗಿದೆ.
ಆಗಿದೆ sir.
ನೋಡಿ.
ಆಮೇಲೆ R2 ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ವಿ, ನೋಟಿಸ್ ಇದಾಗಿದೆ. Post for hearings.
Date, when it was admitted?
8/7/21.
As per order dated, so and so. The date on that point. ಆಗಿದೆ sir. Admitted.
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಇದು ಸ್ಟೆಪ್ಸ್ ಅಂತ ಬಂದಿತ್ತು R2 ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ವಿ.
ಇಲ್ಲ. Admit ಅಂತ ಆಗಿದೆ. Admitted sir.
No, 8/7/21 ಅಡ್ಮಿಟ್ ಅಂಡ್ ಸ್ಟೇ ಆಗಿದೆ sir.
Yes, address the arguments on admission.
Next date. Again, next date.
Sir, your
All
petition is of the year 2021.
Actually, it was in my note, my lord, 8/7/21 stay.
You
admitted.
admitted your petition yourself first. Court has not admitted. That is the problem.
I will verify and then next I will.
ನೀವು admit ಅಂದ್ಕೂಡ್ಲೆ ಇಲ್ಲಿ admit ಆಗಲ್ಲ. Counsel for the petitioner prays for time. The criminal petition is of the year 2021. I do not find any reason to adjourn the matter. Counsel for the petitioner undertake to address his argument on the next date of hearing. List finally as a last chance. Next.
Number 17.
Get ready. Next date of hearing, no.
will-
Next. Please, you are the- SCGP to take notice for respondent number, just one. Issue notice to respondent number 2, if PF with correct address are furnished. Next.
Serial number 18, this is Prasanna, K. Chandrasekhar.
Petitioners for the accused for the offense under section 498A 3 and 4 of DP Act, my lord.
Are respondent contesting it, R2, Chandrasekhar. Yes,
Yes,
who is the petitioner?
petitioners are the father, accused number 1, your husband is not before this, your lordship, my lord.
They are accused number 2,
228, my lord.
2, 4.
228, accused number 3, mother is no more, as such, she is not before your lordship. The first petitioner is the father of the husband, my lord.
Yes,
Second petitioner is the sister of the husband. Third petitioner is the brother-in-law. The fourth and fifth petitioners are the far relatives. They are not the members of the family.
4th and 5th.
Fourth and fifth.
Then
And sixth petitioner is the brother of the accused number 1, husband. The allegation is that, my lord, the marriage of the second respondent with the accused number 1 was performed on 2008, my lord.
date
8/5/2008, my lord.
8/5.
2008,
Yes.
and at Hassan, my lord. Thereafter, since the second respondent and first accused who are employees in Bangalore, they have started their marital life at Bangalore, my lord.
No, whether investigation was undertaken.
Yes, investigation,
It is
charge
filed.
sheet is filed, my lord.
Where is it?
In charge sheet in page number,
Come to page 42.
yes, my lord. In page number 43, my lord.
42.
40. ಈ ದಿನ ಫಿರ್ಯಾದಾರ ಶ್ರೀಮತಿ ಅರುಣಾಕ್ಷಿ
ಎಲ್ಲಿ ಅದು 42? Column number 17 of the charge sheet.
ಎಸ್ ಮೇಲರ್ ದಿನಾಂಕ 8/5/2008 ಆರೋಪಿ ಸಾಕ್ಷಿ 1ರವರು ವಿವಾಹವಾಗಿದ್ದು ವಿವಾಹದ ಮಾತುಕತೆಯಲ್ಲಿ ಆರೋಪಿ 1ರಿಂದ 8ರವರು ವರದಕ್ಷಿಣೆಯಾಗಿ 5 ಲಕ್ಷ ನಗದು 250 ಗ್ರಾಂ ತೂಕದ ಚಿನ್ನಾಭರಣಗಳನ್ನು ಕೊಡುವಂತೆ ಒತ್ತಾಯ ಮಾಡಿ ಸಾಕ್ಷಿ 2ರವರಿಂದ
ರು 5 ಲಕ್ಷ ನಗದು ಹಣ ಹಾಗೂ 200 ಗ್ರಾಂ ತೂಕದ ಚಿನ್ನಾಭರಣಗಳನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಮದುವೆಯಾದ ನಂತರ ಸಾಕ್ಷಿ 1ರವರು ಚನ್ನಮ್ಮನಕೆರೆ ಅಚ್ಚುಕಟ್ಟು ಪೊಲೀಸ್ ಠಾಣಾ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ ಬನಶಂಕರಿ 3ನೇ ಹಂತ ಕತ್ರಿಗುಪ್ಪೆ 5ನೇ ಕ್ರಾಸ್ ಶಾಮಣ್ಣ ಬಿಲ್ಡಿಂಗ್ ನಂಬರ್ 54ರ ವಿಳಾಸದ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರುವಾಗ ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತಂದಿಲ್ಲವೆಂದು ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತರಬೇಕೆಂದು ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಕಿರುಕುಳ ನೀಡುತ್ತಿದ್ದು ಹೆಣ್ಣು ಮಗು ಎತ್ತಿದೆಯಾ ಎಂದು ನಿಂದಿಸಿ ನಿರಂತರ ಕಿರುಕುಳ ನೀಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 24/8/2015 ರಾತ್ರಿ ಆರೋಪಿ 1ರವರು ಸಾಕ್ಷಿ 1ರವರೊಂದಿಗೆ ಜಗಳ ತೆಗೆದು ಹಿಡಿದುಕೊಂಡು ಹೊಡೆದು ನೋವುಂಟು ಮಾಡಿರುವುದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿದೆ. ಆದ್ದರಿಂದ ಆರೋಪಿಗಳ ವಿರುದ್ಧ ಕಲಂ 498A ಸಹಿತ 34 IPC ಮತ್ತು 304 DP Act ರೀತಿ ಪ್ರಕರಣವನ್ನು ಮಾಡಲಾಗಿರುತ್ತದೆ. Since 2008 to 2015, there were no complaints. No allegation is made. The second respondent working as the cashier in a bank and first accused who is working in a SK private company, my lord. And both of them residing in Chanamarkere Achukettu limits at Bangalore, my lord. The first petitioner, who is the father of the accused number 1, aged about 78 years. Residing at Hassan, my lord. Along with 6th petitioner, my lord. Sixth petitioner, who is the brother of the accused number 1. The accused number 1 and respondent number 2 never led their marital life at Hassan, my lord. Since both of them were the residents of Bangalore and they got the job, they are in job at Bangalore, my lord. They led their life in Bangalore. And the second petitioner, Shaila, she is the sister of the accused number 1. And third petitioner, who was in the Indian Army, my lord. Third petitioner.
Yes.
At the time of this complaint also, he was in service in Army, my lord. And at the time of marriage of this second respondent with the first accused also, he was Army and he was serving at Assam, my lord.
Presently,
My lord.
at present.
At present, he is retired, my lord. His service is completed at present, my lord. And at the time of complaint, filing the complaint also, he was in service, my lord. And this petition number 4 and 5,
Yes.
who are not the close relatives, and they have not participated in any events, my lord. But they were implicated in this case by alleging that they were participated in the marriage talks and all those things are bold allegation is made, my lord, against them, my lord. And the first accused has filed the divorce petition before the family court at Bangalore, my lord.
MC number
MC number 4355/2015, my lord.
4355 of
55/2015, my lord. Filed on 23/9/2015.
What happened to that?
That MC is pending, my lord. And also she has filed the domestic violence case against all these petitioners, my lord.
Criminal miscellaneous.
Criminal miscellaneous number 138/2015 15, my lord.
When that was filed,
My lord,
when that was filed,
it was date of filing, I have not permission. 2/38 of 2015 in Annexer H, my lord. Date is not forthcoming, my lord. Annexer H, 2/38 for 2015. And also she has filed one more criminal miss before the family court for maintenance against the husband. That's also pending, my lord.
is pending,
Maintenance petition is filed
125.
125 before the family court.
Criminal petition number,
Why not 2 for 2019, my lord? 502/2019 Annexer K.
I know.
502, why not 2, my lord?
That is also pending.
Yes, that's also pending, my lord.
DV Act, that is also pending.
Yes, that's also pending, my lord.
Yes, what is it?
Please, my lord. At the initial, there was a demand for dowry by these all
It
accused,
was
my
in the year
lords.
2008.
Yes, my lords.
Huh.
Since then, there was a continuous harassment, my lords, that can be made out from column number 17 also, my lord. And with respect to the
Allegation against
harassment.
accused number 1,
Yes, my
not
lord.
against these petitions.
Yes, my lord. For your honor's kind perusal, I'll just furnish the own certificate that has been taken place.
No, that is against accused number 1. It is not her contention that these accused have assaulted her,
Yes, ma'am.
even as per the complaint.
My lords, as per column number 17 in the last but second line, my lords, there is an incident, my lord, dated 24/8/2015, my lord, where
Read it.
there is an allegation against the accused only, my lords. Charge sheet page number is two.
It is also against accused number 1, not against any other.
Yes, my lords, it is against accused number 1 only, my lords.
Then why
Accused
these
number 1
petitions?
has assaulted, my lords. But there was a demand for dowry by these accused
was 8
persons,
years
my
back.
lords.
And after filing the divorce petition, this complaint was came to be filed.
And all the other petitions are pending, my lords. And the divorce petition came to be filed only after filing of this case, my lords.
No.
Yes, my lords.
Divorce petition was filed according to him on 23/9/2015.
Please, my lord.
Right?
Please, my lord.
My lords, and he assaulted
Filed
her.
in the month of November.
Yes, my lords. On 24/8/2015, he assaulted the victim, my lords.
But accused number 1 is not a petitioner.
Yes.
Petitioners being accused number 2, 4, 4 to 8, 2, 4 to 8. Are seeking to quash the criminal proceedings registered against them in a CC 3381 of 2018. Pending on the file of learned second additional CMM, Bengaluru, for the offense punishable under section 498A of
My lords,
RPC,
one submission may be noted,
under
my
section
lords.
3 and 4 of Dowry Prohibition Act.
These are all the allegations and the harassment made by these petitioners only because she gave birth to the female child, my lord. That is there in column number 17.
Clear abuse of process of law. Clear abuse of process. For all the 7 years, she had no grievance. Suddenly, when he filed the divorce petition, she comes with this petition under DV Act, petition under 125.
My lord, she has stated there was a continuous harassment.
So good. United. Yes. Brief facts of the case are that
16 months.
respondent number 2 being the informant lodged first information against one to 8 alleging commission of the offence punishable under section 498A, read with section 34 and under section 34 of IPC and under section 3 and 4 of Dowry Prohibition Act on 26/11/2015. It is alleged that she had married accused number 1 on eight by 2008. It is an allegation that at the time of filing, the accused have demanded dowry and accordingly cash of rupees 5 lakh and gold ornaments weighing 200 grams were paid as dowry. Later, she gave birth to a female child and thereafter all the accused used to ill-treat her. There was panchayat in the family. In spite of that, accused number 1 had assaulted her on 24/8/2015 in the midnight and caused injuries. When she called the police, accused number 1 had fled from the scene of occurrence. Therefore, she requested the police to register the case and to initiate legal action. Extra investigation was undertaken and the charge sheet is filed for the aforesaid offences against all the 8 accused. As per column number 17 of the charge sheet, the only allegation against these petitioners and deceased accused number 3 is that when accused number 1 picked up quarrel with respondent number 2 on 24/8/2015, only allegation against these petitioners is that they, with common intention, ill-treated her both physically and mentally for not bringing additional dowry. Third so and so. The counsel for the petitioner contended that petitioners are read as accused number 2, 4 to 8. Accused number 3, being the mother, is already dead. Accused number 2 is the father of accused number 1 and he is aged 78 years. He is residing with accused number 8, who is the brother of accused number 1. Accused number 4 is the sister of accused number 1 and accused number 5 is her husband. Since accused number 5 is serving in the army, he was posted in Assam at the time of the so-called incident. Now he is retired from service. Both accused number 4 and 5 are residing separately. Accused number 6 and 7 are the far relatives of accused number 1. Both of them are residing in Bengaluru. When counsel submitted that the accused number 1 had filed MC 4355 of 2015 on 23/9/2015 against respondent number 2 seeking dissolution of marriage. It is only thereafter the present complaint was deemed to be filed on 26/11/2015, making bald allegations. She has also filed criminal misdemeanors 138 of 2015 under the provisions of Domestic Violence Act. on 15/12/2015. If she is further filed a criminal miscellaneous file not 2 of 2019 under section 125 of CRPC. All these proceedings are still pending. This shows the conduct of respondent number 2 in filing a false complaint, making baseless allegations. Against these petitioners, there is only bald allegations. And even after investigation, nothing has been found against these petitioners. It is nothing but abuse of process of law, and hence the case for allowing the petition. Per contra, another additional SPP opposing the petition submitted that admittedly respondent number 2 married accused number 1 during 2008. She was being ill-treated after receiving the dowry, and there was demand for additional dowry. Since respondent number 2 gave birth to a female child, all the accused were ill-treating her. On 24/8/2015, the accused assaulted her and caused injuries. There are prima facie materials to attract the penal provisions, hence placed for dismissal of the petition. Peruse the materials found for consideration. My answer to the point in the affirmative for the following reasons. Respondent number 2 filed the first information on 26/11/2015, alleging that at the time of her marriage on 8/5/2008, there was demand for dowry, and the dowry of 55 lakh in cash and 200 grams of gold jewelry were given. Therefore, after committing the offense under DV Act, it took about 6 to 7 years for the informant to file the first information. However, there is bald allegation that there is a demand for additional dowry by all the accused. Except such bald allegation, no other allegations against the petitioners. It is the specific contention of respondent number 2 that on 24/8/2015, in the midnight, it was accused number 1 who assaulted her and caused injuries. However, accused number 1 is not before this court seeking quashing of the criminal proceedings against these petitioners, except making bald allegations regarding demand for the dowry. No other allegations are made, and there are absolutely no material that prima facie disclose the commission of the offense. Next point, it is pertinent to note that admittedly, the petition accused number 1 filed MC 4355 of 2015 on 23/9/2015, seeking dissolution of marriage. It is only thereafter the first information came to be filed on 26/11/2015, and the FIR was came to be registered. The conduct of respondent number 2 also could be seen at the. It is also pertinent to note that criminal miscellaneous 138 of 2015 was filed by respondent number 2 under the provisions of Domestic Violence Act against aggressor on 15/12/2015. Apart from that, she has filed criminal miscellaneous number 502 of 2019 under section 125 of CRPC. All these developments discloses that the respondent number 2 had recourse to law against the petitioners only after accused number 1 filing a petition seeking dissolution of marriage. Next para, even though the allegations are made, the serious allegations are made, their effort, they are only against accused number 1. The bald and general allegations against these petitioners for demanding dowry or additional dowry is not prima facie. The allegations against these petitioners for having demanded dowry is based on bald and general allegations. The parents of accused number 1 is a sister, brother, brother-in-law, and relatives were roped in to file the complaint. Considering all these facts and circumstances, I am of opinion that there are no prima facie materials to proceed against these petitioners. Institute the offense as alleged. Continuation of the criminal proceedings against these petitioners will be abuse of process of law. Therefore, the same is to be quashed. Accordingly, I answer paper point in the affirmative. Petition allowed. Next.
withdraw ಮಾಡ್ಕೊತಾರೆ. FIR stage ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
17. ಏನಾಗಿದೆ? ಬೇಡ. Counsel 17. Counsel for the petitioner filed a memo seeking permission to withdraw. Yes, dismissed as withdrawn. Yes, next.
Number 19, Rajendra Pair, Gopal Krishnamurthy.
I appear for the petitioner, my lord. Kindly pass over me.
So, next.
File objection.
An objection, 2021 matter.
On the ground, but that we have not made the company as a party, but we have specifically mentioned in the corporate itself that the managing director represented by so and so company.
Argue on merits. Yes, they are ready. Pass over.
Pass over.
Yes.
Serial number 20, Devrajam.
I am for the petition.
Yes.
My lord, accused number 1 to 3, 5 to 18, 20 to 23, 25 and 26, 28 to 50, 53, 52, 53 and 55 are before the sub court as petitioners 1, 2.
In all, how many accused?
And in all 55 accused.
Who are the petitioners? Please repeat.
My lord, A1 to A3, A5 to A18, A20 to 23,
22,
20 to 23,
23,
25 and 26, 28 to 50,
28 to
28 to 50,
50.
52, 53 and 55 are before this sum.
52, 53 and 55.
55. Before the Supreme Court has petition number 1 to 50. Well, A5 is reported to be dead. A4 is reported to be dead.
A4.
Yes, madam.
A4
That is
or A5?
A4 at petition number 4. A4 and petition number 4 reported to be dead.
What are the offense alleged?
Yes, my lord, the investigator has registered a suo motu complaint against these petitioners for the offense made penal under section 143, 147, 149, 188, 269, 268, 283, and 353 of Indian Penal Code. And the background of the case is, my lord, on 14/7/2020, the petitioner.
1 minute.
This,
Yes, tell me.
please, ma'am. On 14/7/2020, the petition number 31, my lord, would file a complaint before the respondent number 2.
Petition number 31 means accused number? Refer to their status as accused.
Well, yes, my lord, I will refer the status of accused. In the petition itself, I referred all the status of it.
Hmm.
She would file a complaint before the second respondent, my lord. But since he refused to register the complaint,
What was the complaint?
my lord, complaint,
When it was filed?
on the same day, my lord,
Date?
14.
14/7/2020. Page 26.
Page 7. Additional compilation, man. Page 7, ink page 7.
Compilation put on.
But the other instance, my lord, since he did not, since he refused to register the case complaint, this complaint, my lord, they have expressed their anguish to make a dharna before the higher police officers. But thereafter, he registered the complaint in crime number 154. But after registering the crime number 154 for the alleged,
The complaint is dated 14/7/2020.
please, my lord,
On the same day, the FIR was came to be registered.
register, and that at the first instance when they went to seeking to register the complaint, he did not, he expressed reluctant to register the complaint. Therefore, my lord, PW petition number 31 and petition number 1, he expressed anguish to report the same to the higher officials. And then, my lord, he would register the complaint in crime number 154. For the offense made penal under section 143, 147, 148, similar offenses, 149, 323, 324, 427, 448, 503, 504, and 506 of Indian Penal Code, and section 3, subclass 1, R and S of SC/ST Prevention of Atrocities Act.
Against whom?
Against certain Vijay and several others. Being enraged, presumably being enraged with the same alert, the R2 would register the complaint against the petitioners for the offense, alleged offenses in crime number 155. Immediately, my lord, thereafter, one more complaint came to be registered in crime number 156 on the basis of the complaint filed by one of the accused in crime number 154, mother of one of the accused.
No, on the basis of the complaint filed by accused number 34.
30, please, ma'am.
Crime number 154 was registered.
Please, madam, please, madam.
Thereafter, crime number 155 was registered.
Register
That
against
is the
us.
present complaint.
Please, madam,
Present complaint.
present in question.
In how many accused? 55.
But 55 accused, madam. In the first instance, he would register against 35 years old, my lord. Thereafter, by filing memo, he would register later, I will take your lordship. And thereafter, my lord, after registering 155, he would register one more crime in crime number 156 of 2020 by taking the complaint from the mother of the one of the accused in crime number 154. But during the course of investigation, my lord,
The complainant in 156 is?
156 is mother of one of the accused in crime number 154. Mother of Raghu. Raghu is one of the accused in 154.
Yes.
My lord, during the course of investigation, my lord, the parties in crime number 154 and 156, they settled their disputes outside the court at the instance of the elders in the village. And therefore, my lord, those two cases in crime number 154 and 156 ended in closure of by filing the B report.
Yes.
My lord, now, my lord, this case remained against the petitioners. My lord, the investigation, the legal aspect, my lord, the complaint being the investigation, my lord, he cannot register his own complaint.
Where is the first information?
My first information report, my lord, your lordship would get it in page 26. Gist, my lord. First information start in page 19.
The report submitted to the court.
Please. Report, my lord. Gist, my lord, lordship get it at the report to page, it starts on page 26, my lord. In page 26. Maluru police ಠಾಣೆಯ PSI ಕಾಸು ಆದ KS ಆಂಜಿನಪ್ಪ ಆದ ನಾನು ತಮ್ಮಲ್ಲಿ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ದಿನಾಂಕ 14/7/2020 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಚಿಕ್ಕ ತಿರುಪತಿ ಗ್ರಾಮದಲ್ಲಿ ಗಸ್ತಿನಲ್ಲಿ ಇದ್ದಾಗ ಬಂದ ಮಾಹಿತಿಯ ಮೇರೆಗೆ ಮಾಲೂರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನನಗೆ ನೀಡಿರುವ ಪೊಲೀಸ್ ಜೀಪಿನ ನಿಸ್ತಂತು ಮೂಲಕ ಸಿಬ್ಬಂದಿಯವರನ್ನು ಠಾಣೆಯ ಮುಂಭಾಗದ ರಸ್ತೆಗೆ ಬರುವಂತೆ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆಗೆ ಠಾಣೆಯ ಬಳಿ ಬಂದು ನಾನು ನೋಡಲಾಗಿ ಮಾಲೂರು ಮಾರಿಕಾಂಬ ವೃತ್ತದ ಕಡೆಯಿಂದ ಸುಮಾರು 60 ರಿಂದ 70 ಜನರು ಅಕ್ರಮವಾಗಿ ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ತಮಟೆ ಬಾರಿಸಿಕೊಂಡು ಪೊಲೀಸರ ವಿರುದ್ಧ ಘೋಷಣೆಗಳನ್ನು ಕೂಗುತ್ತಾ ದಿನಾಂಕ 13/7/2020 ಸಂಪಂಗೆರೆ ಗ್ರಾಮದಲ್ಲಿ ರಘು ಮತ್ತು TPS ಮುನ್ರಾಜು ಅವರ ನಡುವೆ ಗಲಾಟೆ ಆಗಿದೆ ಎಂದು ಹೇಳಿ ಠಾಣೆಗೆ ಬಂದು ಯಾವುದೇ ದೂರನ್ನು ನೀಡದೆ ಅಕ್ರಮ ಕೂಟ ಕಟ್ಟಿಕೊಂಡು ಮಾಲೂರು ಪೊಲೀಸ್ ಠಾಣೆ ಮುಂದೆ ಮಾಲೂರು ಹೊಸೂರು ರಸ್ತೆಯಲ್ಲಿ ಪೊಲೀಸರ ವಿರುದ್ಧ ಘೋಷಣೆಗಳನ್ನು ಕೂಗುತ್ತಾ ಪ್ರತಿಭಟನಾಕಾರರಿಗೆ COVID-19 ಪ್ರಯುಕ್ತ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಪ್ರತಿಭಟನಾಕಾರರು ಸಾಮಾಜಿಕ ಅಂತರವನ್ನು ಕಾಪಾಡಿಕೊಳ್ಳದೆ ಮಾಸ್ಕ್ಗಳನ್ನು ಧರಿಸದೆ ಓಡಾಡಬಾರದು ಸರ್ಕಾರದ ಆದೇಶವಿದೆ ಎಂದು ಪ್ರತಿಭಟನಾಕಾರರಿಗೆ ಜೀಪಿನ ಮೈಕ್ನ ತಿಳಿಸಿದರೂ ಸಹ ಪ್ರತಿಭಟನಾಕಾರರಾದ ಮಾಲೂರು ತಾಲೂಕಿನ ಸೋನ್ಸೋ ಆಲ್ ದಿ in page 27 against 35 persons initially registered. ದೊಡ್ಡಿ ವಸಂತ ಸೋನ್ಸೋ ಗ್ರಾಮ ಮತ್ತು ಇನ್ನೂ ಇತರ 30 ರಿಂದ 40 ಮಹಿಳೆಯರು ಮತ್ತು ಪುರುಷರು ಪ್ರತಿಭಟನೆ ಮಾಡುತ್ತಿದ್ದಾಗ ಸಮವಸ್ತ್ರದಲ್ಲಿದ್ದ ಅಧಿಕಾರಿಗಳಾದ ನಾನು ಮಹಿಳಾ PSI ಶ್ರೀಮತಿ ಎನ್ ರಂಗಲಕ್ಷ್ಮಿ ಮಾಸ್ತಿ ಪೊಲೀಸ್ ಠಾಣೆಯ PSI ಬಿ ಪ್ರದೀಪ್ ಸಿಬ್ಬಂದಿಯರಾದ ASI ಸೋಮಶೇಖರ್ ASI ರಾಮಕೃಷ್ಣ SC 164 ವೆಂಕಟೇಶ SC 147 ಈರಣ್ಣ SC ಸೋನ್ಸೋ ಬಾಬು ಸೋನ್ಸೋ ಮುನಿರತ್ನಮ್ಮ ಮಾಸ್ತಿ ಠಾಣೆಯ ಸಿಬ್ಬಂದಿಯವರಾದ SC ಸೋನ್ಸೋ ವೆಂಕಟೇಶ್ ರವರು ಇದ್ದು ಅಕ್ರಮ ಕೂಟ ಸೇರಿಕೊಂಡವರನ್ನು ಪ್ರತಿಭಟನೆ ಮಾಡಲು ಯಾವುದೇ ಪೂರ್ವ ಅನುಮತಿ ಪಡೆಯದೆ ಮಾಲೂರು ಹೊಸೂರು ರಸ್ತೆಯ ಪೊಲೀಸ್ ಠಾಣೆ ಮುಂಭಾಗದ ರಸ್ತೆಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಕುಳಿತುಕೊಂಡು ವಾಹನಗಳು ಮತ್ತು ಸಾರ್ವಜನಿಕ ಸುಗಮ ಸಂಚಾರಕ್ಕೆ ಅಡ್ಡಿಪಡಿಸಿ ವಾಹನಗಳನ್ನು ತಡೆದು ನಿಲ್ಲಿಸಿದ್ದು ಕರ್ತವ್ಯದಲ್ಲಿ ಇದ್ದ ನಾವುಗಳು ಪ್ರತಿಭಟನಾಕಾರರಿಗೆ ರಸ್ತೆಯನ್ನು ತೆರವು ಮಾಡಿ ವಾಹನಗಳ ಸುಗಮ ಸಂಚಾರಕ್ಕೆ ಅನುವು ಮಾಡಿಕೊಟ್ಟು ಪ್ರತಿಭಟನಾಕಾರರಿಗೆ ನಿಮ್ಮ ದೂರು ಏನಾದರೂ ಇದ್ದರೆ ನೀವು ಠಾಣೆಗೆ ಬಂದು ದೂರು ನೀಡಿ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ತೆಗೆದುಸುವಾಗಿ ಮನವಿ ಮಾಡಿಕೊಂಡರೂ ಸಹ ನಮ್ಮ ಮನವಿಯನ್ನು ಧಿಕ್ಕರಿಸಿ ಹಾಗೂ ನಮ್ಮ ಕರ್ತವ್ಯಕ್ಕೆ ಅಡ್ಡಿಪಡಿಸಿ ರಸ್ತೆಯ ಮುಂಭಾಗದಲ್ಲಿದ್ದ ಕುಳಿತು ವಾಹನಗಳನ್ನು ಮತ್ತು ಸಾರ್ವಜನಿಕ ಸುಖಕ್ಕೆ ಸಂಚಾರ ಅಡ್ಡಿಪಡಿಸುತ್ತಾರೆ. Lord, next, my lord, again, in page 29, my lord, you would had some more witness, some more accused
Yes.
as 36 to 35. My lord, in this petitioners, my lord, the advocates of the petitioner number 31, 3 advocates also came to be implicated. Petition number 19, 36 and 50 are the advocates of the petition number 31. My lord, the main offense is 353. My lord, not to constitute an offense made penal under section 353. Number one, just to repeat, though your lordship, my lord, every day reads, just to refresh your lordship memory, 353, my lord.
Yes.
Assault or criminal force to deter public servant from the discharge of his duty. Whoever assaults or uses criminal force to any person being a public servant in execution of his duty as such public servant, or with intent to prevent or deter that person from discharging his duty as such public servant, or in consequence of anything done or attempted to be done by such person in lawful discharge of his duty as such public servant, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. My lord, by reading of the entire complaint, my lord, again and again, the vital ingredients to constitute the offense alleged in the case are not forthcoming. And there is no specific overtake attributed to each of the petitioners. My lord, 50 persons, preventing one person or assaulting a public servant, lord, that is not there in the complaint. It's even imagine, my lord, nothing is there to suggest.
That has become the order of the day now.
Allah, my lord, if somebody is not addressing my grievance, but assume for a moment, for the sake of argument, and if I say that I am going to protest.
Have the remedy under law.
Yes, my lord.
Not protesting against the police by
Lord,
indulging in high-handed action.
That has been created, my lord.
It is
The
for
all the
evidence.
thing,
It is
all
for
the
the
thing,
evidence.
I have complained to them, I will complain to them. My lord, you would register the crime number 154, immediately you would register 155, again you would register 156.
Yes.
But these circumstances would portray, my lord, these petitioners have been falsely booked, and this is the abuse of process of law, my lord. The investigation officer has taken the law into taking undue advantage of the position.
Go for trial. No, it is not a case for question.
My lord, so many petitioners are there, my lord, even
Let him
three of them.
be.
My lord, three of them not even present. The advocates who are the advocates representing the petition number
Cannot
31 in
presume
civil
so many
case.
things, sir.
And my lord,
When a public servant makes specific allegations, we cannot start doubting him.
my lord, at the same time, my lord, again, my lord, the page 29, you would say, I came to know on the basis of the hearsay, my lord. On the basis of the hearsay, the personal liberty of a person cannot be taken away.
Identification of those persons were made later. By
My lord,
names.
that
by
is not
naming
there. That is not there at all, my lord. Not even a iota of evidence, small evidence, my lord.
No, nothing.
No, ಅಷ್ಟೊಂದು ಜನದ ಮೇಲೆ 354, my lord. If this, my lord, they would take their law into their
354, COVID-19.
But COVID-19, my lord, in similar
were also-
circumstances, my lord, the coordinate benches, my lord, quashed the proceedings into the.
I am not bound by any of those things. It all
Right.
depends on facts and circumstance of each case.
My lord, the same similar circumstance where they protested. Where they protested, my lord, unfortunately, it is a full order.
Full order ilde ಮತ್ತೆ.
ಅಲ್ಲ, ಅದು details ಇದು ಮಾಡಿಲ್ಲ.
Lords,
Then I'll place it,
investigation
my lord,
has not yet completed, my lords. And they have formed the unlawful assembly during the period of COVID, my lords. And they have protested against the police people and my lord, and they have obstructed the general public at large, my lord, for their moment. And my lord, if they have some grievance, my lord, against the concerned police, they would have approached the higher authorities, my lord. Without approaching a higher authorities and making an unlawful assembly and protesting against the government officials and restraining them and obstructing them from discharging their official duty is an offense, my lord. And that too, that has been taken place during the period of COVID-19. They have violated the terms and conditions which have been implemented at that time, my lords. The petition has to be dismissed, my lords.
Madam, it could introduce.
And specific names have been mentioned in the FIR also, my lords. In the complaint also, my lords. Not one or two, there are several police officers, my lords, at that time on duty.
Yes.
Please, my lord, the guidelines formulated in the present last case, my lord, certainly would applicable to this case.
Yes.
My lord, your lordship well aware that, my lord. And the specific word act is not attributed to each of it. Mere presence, my lord, mere presence of so many people, my lord, that doesn't mean that, my lord, all the petitioners has participated and all the petitioners have formed unlawful assembly and have had an intention to prevent the public servant from
My lords,
discharging.
entire incident has been videographed
submit,
and
ma'am.
photographed, my lords.
That has not been produced.
I'll place it on record, my lords.
Charge sheet is not yet filed.
Not yet filed.
No.
Interim order is there.
No, my lords.
Interim orders.
Till- Vidya.
Interim orders.
Yes.
But Tribunal case, my lord, the mere presence of, the court would say, my lord, mere presence of the accused cannot be termed as an unlawful assembly.
Yes.
My lord, therefore, my lord, this prima facie case is not made out.
Yes. So good. Petitioners. Being accused numbers 1 to 3, 5 to 18, 20 to 23, 25, 26, 28 to 40, 52, 53, and 55. Being the petitioners.
My lord, on submission,
Yes.
I may permit to withdraw with liberty to file after final.
After
Final.
counsel for the petitioner, after addressing the argument at length, seeks permission to withdraw the petition,
The final report is filed against the petition.
file fresh. The liberty to approach this court afresh after filing of the final report. Permission is placed on record, petition dismissed with liberty as sought for. Yes.
Great.
Yes. Yes.
Your lordship confirmation, serial number 8 and list number 3, only correction of case crime number in bail order granted by your lordship.
What is the correction to be made?
Correction, in preamble, crime number year 2014 is mentioned instead of 2021.
Serial number 8, is it?
Yes, my lord.
Where is the mistake?
In preamble, crime number 242 of 2024 is there. It ought to be 2021, my lord.
Time number?
242 of 2021.
Yes.
In the page number 1 also, court number 13th additional, not 12th additional. Page number 1 and operative portion also.
13 ಇದೆ 13th additional city civil.
Page number 2 ನಲ್ಲಿ 12 ಇದೆ. ಲೈನ್ ನಂಬರ್
13th ಆಗ್ಬೇಕು.
13th ಆಗ್ಬೇಕು. ಮತ್ತೆ ಪೇಜ್ ನಂಬರ್ 5 ನಲ್ಲಿನ 13th ಆಗ್ಬೇಕು. ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಷ್ಟೇ.
Third line of counsel, serial number 8. Third line of counsel for the petitioner on the application. Time of receipt is noticed that the mistake has crept in at page number 1 in mentioning the crime number, and in page number 2 and also in the operative portion while mentioning the name of the additional city civil and sessions court. This is directed to correct the same as suggested and to furnish fresh certificate copy.
My last list 1, serial number 9, my lord. It will become infructuous, my lords, as acquittal order has been passed on 24/8. List 1, serial number 9, my lords.
9. Additional SPP submits that
Acquittal order dated 24/8/2023, my lords.
the trial court has already disposed of the matter after full-fledged trial by acquitting the accused with a judgment dated 24/8/2023. Submission is placed on record. Petition is dismissed as the same is rendered infructuous.
Serial number 13, my lords. In view of order dated 13/6/2024, it will become infructuous, my lords. They ought to have complied the office objections within 1 week, my lords.
Yadu serial number?
13, my lords.
Huh.
Wide order dated 13/6/2020. Yes.
Yes. ನೀವೇ ಇದ್ದೀರಾ the petitioner?
Now,
Yes.
I withdraw my submission.
Serial number 23, I pray for time, Mara.
Which one?
I have serial number 23, list 2. I have requested the other side also, Mara. I am for the petitioner. Yes. 23.
What is that?
I pray for time.
ಏನಾಗಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ 2018 matter, sir.
Next date we will go on, my lord.
23. Counsel for the petitioner, prays for time. He undertakes to address the argument on merits on the next date of hearing without fail. Petitioners.
That interim order may kindly be
And
extended.
the last chance. Subject to the condition that the learned counsel, the petitioner addresses his arguments on the next date of hearing, interim order. He did next year.
Much.
Bill number 21, my lords. I pay for respond number 2, my lords. The other side also, short accommodation, my lords. Senior.
21.
21, my lords.
Let them address the argument. Wait for some time. You are for the respondent.
Senior is not available.
Wait for.
Your
you are-
lordship.
Be present.
Your lordship, serial number 32, your lordship. The counsel is before Honorable Supreme Court, your lordship. So the counsel, for the petitioner is before Honorable Supreme Court, your lordship. So he could not attend the matter today. So any short date during next week, your lordship. I'm a proxy counsel in this matter. I was requested to make a mention.
That cannot be the ground. Merely because he is before the Supreme Court, what I have to do? I have to retire for the chamber, is it?
He is requested for a short accommodation. Next day or in,
Making such submissions. By referring to the Honorable Apex Court, you can make, seek any number of adjournment, is it? Otherwise, do you mean to say that by referring to the Apex Court, I will grant the time?
no, your lordship, is
Then-
that due to his unavailability, I'm.
I will not adjourn. Merely on that ground, I will not adjourn. Next,
Serial number 28, madam. Senior is not feeling well today.
20.
28, madam. List number 2. I am for the appellant in this case.
Final hearing, 2015, no.
One week time is-
No. 9 years have lapsed. Noted.
Date of hearing we have.
Wait. Noted.
Serial number 26, my lord. I appear for the respondent state. I have been appointed as a special public prosecutor in this matter. In the
Serial
place of Prasanna Kumar, serial number 26 on the second list. Prasanna Kumar idru, he has resigned from the post, my lord. I have been appointed, Tejesh P. Just given my name may kindly be shown in the cause list.
ನಿಮ್ಮ ಹೆಸರು ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ, my lord, I was
So
pleased.
and so submits that. 26 ಅಲ್ಲಿ already adjourn ಆಗಿದೆ. So and so submits that. He represents respondent number 1 as Mr. P. Prasanna Kumar. He is no longer represents the respondent. Motion is placed on record. Office is directed to delete the name of Shri P. Prasanna Kumar for respondent number 1 and to show the name of so and so.
Please, ma'am.
Yes.
Please.
ಪಾಸ್ ಓವರ್. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಅದಕ್ಕೆ ಅಲ್ಲ, ಬಟ್ ಬಿ ರಿಪೋರ್ಟ್ ಏನೋ ಹಾಕಿ. ಅಯ್ಯ ನಂದು ಕರೆದು ಬಿಡಿ. ಧಾರವಾಡ ಆಮೇಲೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಹೇಳಿ.
ಧಾರವಾಡ ಹೈಕೋರ್ಟ್ಲಿಂದ ಮೇಡಮ್.
ಹಾ ಸರ್, ಆಡಿಬಲ್ ಇದ್ದೀರಾ?
ಹಲೋ
ಮೇಡಮ್, ನಾವು ಪೆಟಿಷನರ್ ಸರ್. ಅದು ಕರೆಕ್ಷನ್ ಇದನ್ನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ.
ಆಗ್ಲಿ ಮೇಡಮ್.
ಮೇಡಮ್ ಆಡಿಬಲ್ ಇದೆನಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಸುಯೋಗ್ ಆಫೀಸರ್ ಆಗಿಲ್ಲ.
ಅದು ಸ್ಪೆಷಲ್ ಪಿ ಪಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ವಿ. ಇದರಲ್ಲೂ ಮೇಲ್ ಎಕ್ನಾಲಜ್ಮೆಂಟ್ ಬರ್ತಾರೆ ಹೇಳಿ. ಸ್ಟೇಟ್ ಆಫ್ ಕನ್ನಡ, ಬಟ್ ಸ್ಪೆಷಲ್ ಪಿ ಪಿ ಸರ್ವ್ ಆಗಿದೆ, ಅವ್ರು ಬರ್ತಾರೆ. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅವರು ಬರ್ತಾರೆ. ನಿಮ್ದು ಇದಾದ ಕೂಡ ಬರ್ತಾರೆ ಅಂತ.
Matter pertaining to Dharwad bench, hearing on IA, serial number 1, Vidyavati, Chetan Munoli, government advocate.
Please, my lord, I appear for petitioner, my lord. There is a correction in the, it is mistake made by the petitioner itself, my lord, at the time of drafting. Petitioner number 10, father name is Ramappa, my lord. Instead of that, it is Jinappa is type.
You committed the mistake.
Yes, my lord, it is mistake of mine. Therefore, I have made a application for correction under section 152 of the CPC. In the petition itself, petition and judgment. And also, my lord, in respect of that, my lord, I made a correction, my lord, but it is not typed. Respondent number 5 and 6. It is Jamakandi, my lord, instead of Navanagar.
Then the entire address will change.
No, my lord, only Navanagar ಅಷ್ಟೇ ಹೋಗಿ ಜಮಖಂಡಿ ಆದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. ಬೇರೆದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
the petitioner. Third line counsel for the petitioner on IA 1 of 2024 filed under section 152 of CPC seeking correction of the judgment and the writ petition. It is stated that the father's name of petition number 10 is mentioned as Ramappa Godanawar instead of Jinnappa, Jinnappa. Jinnappa. Similarly, the place of residence of respondent number 6 is shown as Navanagar instead of Jamkhandi. These mistakes were kept in the writ petition itself, and the same needs to be corrected both in the petition as well as in the order. For the reasons stated in the application, I deem it appropriate to permit the petitioner to make necessary corrections in the petition and direct the office.
My colleague is there, my lord. He corrected their own.
In the order dated so and so. Yes, accordingly, IA 1 of 2024 is allowed. Petitioner is permitted to carry out the amendment as sought in the application, in the petition, and the office is directed to so and so. Yes, carry out the amendment.
One request, my lord. Even 5 also, my lord. Respondent number 5 also, my lord. It is also.
5 and 6.
But 5 also, my lord, it is to be Jamkhandi instead of Navan.
5 and 6.
Please. In other 2 matters, my lord, only correction in respondent 5 and 6 only.
Number 2 and 3.
Please, my lord.
The father's name illa, only places instead of Navanagar. Next. Yes,
Please,
carry out the
much
amendment.
obliged.
Please, my lords.
Please.
Please, please, carry.
These 3 matters. Serial number 1 adjourned. Serial number 2 non-compliance of office objection for second time Bojaraja.
Pudi, order sheet. Counsel for the petitioner is absent or representation. The office objections are not complied with this term. Next.
Orders first time enter. Serial number 3 to 7.
CGP to take notice for respondent.
Petitioner's counsel,
Number,
serial number 7.
private respondent ಇದ್ರೆ ಅವ್ರಿಗೆ ಹಾಕಿ. Yes.
Serial number 7, my lord. Then it is Prasanna Kumar is.
May be served.
Copy already served. Learned special PP Prasanna Kumar is appearing, Lord, for
7.
this is pertaining to that matter, my lord, where 2 investigations are going on. The police officers filed complaint against police officer.
Serial number 7.
You served a copy to Prasanna.
We'll file our objections, my lord.
Takes notice for respondent. Yes.
Lord, sought for interim relief, my lord, for the reason is this.
Immediately it will be listed.
My lord,
Be
the-
prepared on the next date.
Please,
In the connected matter, my lord, your lordship already granted bail to me, my lord. Now, my lord, while granting bail to the co-accused, your lordship has made observations that the role is different from my role, my lord. Therefore, my lord, interest may be that
Immediately
some,
I'll take up.
some
When?
protection till the, my lord,
When?
matter is taken up.
Yeah, what?
Tomorrow, my lord.
Tomorrow better. When?
12th or 13th, my lord.
But the long date, my lord, that is the reason why, my lord, even holidays are coming.
9th or 12th? 9th.
But some protection may be granted. Only for the reason is this, my lord. If
Nothing-
they
nothing
won't
to
file
concern.
objections, my lord, within time, my lord, then,
Nothing.
lord,
Nothing. 9th or 12th? 9th.
9th.
Yes, 9th. 9th.
Monday.
For order serial number 8 adjourned. Serial number 9 Harish Prabhu, yes.
For the petitioner, your lordship. It is a petition under section 439, your lordship.
Yes.
Alleged offences are under section 143, 147, 144,
Who is the
109.
petitioner?
He happens to be the accused number 8 in this case, your lordship.
Now, how many accused?
There are 1 to 8. Accused number 6 and 7 have been granted bail by this honorable court, your lordship.
Accused number?
6 and 7 have been granted bail by this
Copy.
honorable court. And even the allegation against the present accused person is also identical to them, your
Copy
lordship.
Kodi.
When he was arrested?
Same allegations, my lords. Against accused number 1, 2, 4, 5, 6 and.
When he was
and
arrested?
8.
He was arrested on 2/2, your lordship, 2/2/2024. The allegation is that the complainant happens to be the relative of the deceased person, your lordship. He states that on 1/2/2024, one of the friend of the deceased person had called upon him and informed that he was attacked by one Shaktiman, Raghunath alias Shaktiman and his gang, your lordship, with 3 pieces and iron rod. Thereafter, your lordship, it is stated to be expired in the Victoria Hospital, your lordship. Your lordship, in the present case, there are 2.
One. Yes.
Your lordship, in the present case, CW2 and CW3 happen to be projected as eyewitnesses, your lordship. Even going through the statement of the eyewitnesses, it is very clear that the allegation of assault on the vital parts of the body are upon accused number 1 to 4. The same is mentioned in the order copy of the accused.
What is it?
My lords, there is a mens rea and actus rea, my lords. There is a clear intention, my lords, to
Parity
kill
with
him.
accused number 6 and 7.
Yes,
Similar allegations. So,
yes, ma'am. Similar allegation.
ಇದು ಕಾಪಿ ಇದೆ ಇದೇ ತರ ಸೇಮ್. Petitioner being accused number 8 is seeking grant of bail under section 439 of the RPC. He was apprehended on 2/2/2024. Since then he is in judicial custody. ಇದು ಸೇಮ್ ಮಾಡಿ accused number 8 ಅಂತ ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. Allowed. Petition is allowed.
Much obliged.
Other matter, this one. Serial number 5, Abhinav Ramanand.
Sir, I'm hearing for the petitioner. My lord, in this matter, my lord, I am given to understand B report has been filed. The left B report is filed. We have challenged the FIR.
Dismiss this as a letter in purpose.
We place it on record because I have,
ಇದೆಲ್ಲ ಆಗುದಲ್ಲ sir. It is finally posted.
I have a
Preemptory order is already passed.
preemptory order ಇದೆ. But what I am given to understand is my lord, B report is filed. If
Either
they
way,
place
the
it on
petition is to
record.
be dismissed.
If they place it on record, it may be disposed, my lord.
I will not wait
Oth-
for anything.
Otherwise, my lords may kindly grant 1 week's time. I'll place it on record, my lord, with the
Please
condition,
for
my
a
lord.
week's time. Produce relevant document to state that B report is already filed by the investigating officer.
I'm not, my lord, I'm not sure, my lord. I'll ascertain. Let there not be such an
This was
observation.
Now you said you
No,
are
that is
seeking
what-
1 week's time.
That is what I'm given to understand.
I am recording your submission.
ನಾವು ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಅವ್ರು ಕೊಡ್ತಾ ಇಲ್ಲ. At least ಅವರಾದ್ರೂ ಪ್ಲೇಸ್ ಮಾಡ್ಲಿ ಇಲ್ಲ ನಾನಾದ್ರೂ
What is
ಪ್ಲೇಸ್
your
ಮಾಡಿ.
submission? Tell me, I will record it.
My lord, my submission is this, my lord. Given to understand, my lord, a B report has been filed.
Learned counsel for the petitioner submits that he was given to understand that B report is filed by the investigating officer.
Like, if a
He
week's
seeks
accommodation is granted, I'll place it on the account.
Produce the same. The petition is of the year 2020. Till date is the office objections are not complied with. The order dated 13/6/2024 reads as under. In spite of that, the office objections are not complied. Moreover, now it is stated that the B report is filed by the investigating officer. And taking into consideration all these facts and circumstances, all these facts, I now fulfill the petition is liable to be dismissed. Petition dismissed.
Allah, next week only I'll place it on.
Next.
Serial number 8, T.A. Karambaya.
My lord, at least with the liberty, my lord, if in case, my lord, any.
ನೋಡೋಣ. ಅದೇನಾದ್ರು ಇಲ್ದೇ ಇದ್ರೆ ನೋಡೋಣ.
Allah, in the event, my lord, no such.
ಸೊ ಅದನ್ನೆಲ್ಲ ifs and buts ಅಂತ ಆರ್ಡರ್ ಬರೆಯಲ್ಲ ಸರ್. ದಯವಿಟ್ಟು ಅದನ್ನ ಮಾಡಬೇಡಿ ಸುಮ್ಮನೆ.
The reason.
It is an order. It will have some sanctity.
I understand, my lord. I
If
understand.
that is so, ಅದೆಲ್ಲ ಮಾಡಲ್ಲ.
Allah,
Yes,
at
next.
least a week's accommodation, my lord,
Next.
I may be.
Rejected, sir.
Serial number 8, T.A. Karambaya.
ಅದು 4 ಏನಾಯ್ತು? 4 ಏನಾಯ್ತು? ಇಲ್ವಾ? ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ 4 ಕೌನ್ಸಿಲ್ ಫಾರ್ ಆಗಿದ? ಸರಿ. 8 ಕೊಡಿ. Counsel for the petitioner is absent, no representation. The criminal petition is of the year 2020. Till date, the office objections are not complied with. Order sheet dated 26/2024 reads as under. In spite of that, the office objections are not complied. Hence, petition is dismissed.
Serial number 10, Moana Kumara D.
Same.
Serial number 11 for non-compliance for 4th time, Jeevan Jain Neralgi.
Lordship, we have misplaced the file, your lordship. 2 days.
Good. ಇಲ್ಲ ಏನಾಗಲ್ಲ ಪ್ರೇಮ್ಟ್ರಿ ಆರ್ಡರ್ ಆಗೋಗಿತ್ತು.
Your lordship, 2 days of time may be please be given, your lordship.
Praise for time on the ground that he has misplaced the file. The petition is of the year 2020. The office objections are not complied with, even though the same is listed for the 4th time. The order sheet dated 12/6/2024 reads as under. In spite of that, there is no non-compliance of office objections. I do not find any reason to examine the matter. Petition stand dismissed.
Your lordship.
Dismissed.
2 days, your lordship.
Sorry, sir, sorry. Next.
Serial number 12, Harishan.
Absent, no representation. Petition is of the year 2020. Order sheet dated so and so reads as under. In spite of that, the office objection. Same, 4th time. Next.
Serial number 13, Government Advocate.
Short accommodation may be given, my lord.
The same. Learned additional SPP days per time. Office objections are not complied, even though the matter is listed for the 4th time. The order sheet dated so and so. Same, dismissed. Next.
Serial number 19, Rajendra Gopal Krishnamurthy. Is to 2.
I appear for petitioner in this case, Lordship. This is the matter pertaining to 138 proceedings, Lordship. The IA number 1 of 21 got stayed on 18/12/2021, Lordship. For the check amount 7,31,400, Lordship. And the check number is 121,872, Lordship. Initially, this check was presented before the Yeshwantpur branch on 28/2020, and later November 9, 2020, again second time it was presented before the Canara Bank of Malur, Lordship. And they issued legal notice and filed the case. My contention, Lordship, in this, the petitioner is not made the company has a party, Lordship. The managing director made the party in the.
Who is the signatory to the check?
Director managing.
Is a company?
Company.
Partnership firm.
Company, Lordship.
ಎಲ್ಲಿದೆ ಕಂಪನಿ ಅಂತ?
Kindly see the annexure 1, Lordship. Memorandum of Article of Association of Gayatri Structure and Roofing Private Limited. Page number 11, Lordship.
You are a respondent, Gopalakrishna Murthy. Morning he was here. So that is the only ground?
Yes, Lordship, and the check is not, check is issued in the name of the respondent, Lordship, neither in the firm which the check was issued nor in the company, Lordship. That is the only contention. Neither in the name of the company nor in the party name, Lordship, check was issued. And it is also covered by the judgment, Lordship, Himanshu versus.
Is this measure Sumukha and engineers?
Yes, Lord. As per it covered by the judgment, Lordship, the company has not made the party, then it is liable to be dismissed, Lordship.
Then
Yes, Lord.
2 grounds.
Yes, Lord.
Yes.
And it,
But the first ground of them is, my lord, we have not made the company
as a party.
party. But my lord, we have specifically stated in the managing director represented by so and so company, my lord. Kindly see the PCR, my lord, annexure B as per their pagination 13, my lord. That is, my lord, the.
Where is it? No, you have arrayed him as a managing director.
Yes, my lord.
A company is not a party.
That's what, my lord, it is a curable defect in nature because, my lord,
Yes. Section 141.
Please. But they are not disputing the check-in question as well as their signature.
Company is not a party.
Only their ground is the company we have not made the party.
Is the
But we have,
requirement under 141?
but my lord, we have specifically stated that they are managing director of Measures Gayatri Structural and Roofing Private Limited.
Oh, managing partner is arrayed as accused, not the company.
Correct, my lord. My lord, if that is the case, my lord, your lordship may kindly allow the petition with the liberty to the respondent to make the
Petition, if petition is allowed, they are seeking quashing.
Not regarding my kind submission
proceedings
is
will be
because, my lord, it is a curable in nature. It is a curable defect, my lord. It is not an incurable defect.
Why all these days you have not taken any steps?
Because, my lord, the stay was there, my lord. That is the reason.
So it cannot be amended. You could have sought permission from this court.
This is the first
When
day
you
after
came to
filing.
know that this is the ground urged by the petitioner,
Correct me.
2021, this petition was filed.
Correct me. But after filing, my
All
lord,
these 3 years, you are not bothered about.
today only the matter is listed, my lord.
So what, sir?
It is my humble request, my lord. Lord,
Till listing of the case, till hearing of the matter, you will not apply your mind?
Lord, certainly, my lord, because my lord,
Why should we
might
apply
be a
our
mistake of the counsel of the honorable trial court. Lord, for that, my lord, client should not suffer. Because even on merits also,
Is the case, we cannot proceed against in any of the matter.
because, my lord, because,
In every case, the advocates commit mistake.
my lord, it's a curable,
The parties will suffer.
Lord, it's a curable defect, my lord. It's not an incurable defect because
And
mere-
moreover, the other ground is check is issued in favor of whom?
Please, my lord.
A2 measures. Trademark engineers. Who is he?
Sumukha engineers only, my lord. We are representing Sumukha engineers only.
Sumukha engineers.
Yes, yes. That ground they cannot take, my lord, because they have not denied it. Sumuka engineers only. Madam. We are for the Sumuka engineers only. That ground they cannot take. Only thing is, we have not arranged the as a party to the company
Yes.
as a party, my lord.
Sumuka engineer
Yes,
is the complainant,
Yes, my lord.
is the managing partner.
Yes, my lord. For them only they have issued the check, my lord.
But there cannot be any ground for for you not amending your petition.
Lord, we are
Complaint.
ready, my lord, because my lord, since the
Sir, you are ready, but you are not doing that.
because my lord, the
All advocates are ready.
Lord, because my lord, the dishonorable
Ready.
dishonorable court was pleased to grant this stay, my lord.
You
We
could have
cannot
brought it to
amend
the
it before the
notice.
trial court, my lord. That is the reason.
That could have been brought to the notice of the court.
But after filing of Wakalat, my lord, this is the first time matter is listed. That is the reason in the morning session,
Now
my
you
lord.
are saying petition may be allowed.
Lord,
If
only in
petition
respect
is allowed,
with a liberty, my lord,
goes.
to the respondent, my lord.
Now, once the petition is allowed, what remains, sir?
But regarding the liberty to the respondent, lord, to means permit me to make him as a means company as a party to the proceedings, my lord. On that ground, my lord, the entire on merits it should not be, my lord. That is my humble request, my lord. Because my lord, they
Tell me what
are
should be the operative portion of the order? Tell me.
because my lord,
It
your
is very
lordship
easy to stand there and say something.
is not like that, my lord. Is my humble request is, my lord.
Petition is allowed.
My lord, they are not
Subject-
denying my case on merits, my lord.
Tell me what should be the order?
Because my lord, we have specifically stated so, and even in the legal notice also we have stated.
The ground made out is sufficient to allow the petition. The petition cannot be dismissed. Under such circumstances, what should be the order?
Even my lord, in the reply notice, my lord, which they have taken.
That is all on merits.
Yes, my lord.
That is all on merits.
But because my lord, the respondent should not suffer because yeah, they have as
They
per
will
the
suffer for having engaged such advocates. What should be done? It is
proceedings of
nothing
state,
but sheer negligence for 3 years.
trial court,
Hmm.
they were not able. Matter is.
No, consumer forum ಹೋಗ್ತಾ ಇಲ್ಲ ಯಾರು. ಹೋದ್ರೆ ಎಲ್ಲ ಸರಿ ಆಗುತ್ತೆ. Separate ಆಗುತ್ತೆ.
That is the reason, my lord, in the morning session, I have requested your lordship to file my objections along with that application. That is my,
Even if you file an objection, that cannot be the ground.
along with my application, my lord, I was ready
It
because.
is wholly on technicalities.
Yes, my lord, that is
Yes.
the reason.
Then
With application, my lord, I was about to file that application. That is my lord, humble request in the morning because today is only the, after filing of my local matter is listed, my lord. That is the reason.
no. ಏನ್ ಮಾಡ್ತೀರಿ? Even if you get some time, you cannot do anything.
Certainly I will do it, my lord.
What you will
I
do?
will file application regarding that, my lord.
Where?
By seeking the
Before
permission,
this court.
that the vacating IA, I will file here, my lord, by requesting this honorable court.
Vacating IL entertain
On
ಮಾಡಲ್ಲ.
merits.
Already I have taken up the matter.
On merits, my lord, I was about to file application regarding permit this honorable court to make the means party
Tomorrow.
person to before the
Third learned
honorable
counsel for
trial
the
court.
petitioner. Then counsel for respondent pays for a day's time. This tomorrow.
Please,
Much obliged.
right.
Serial number 21, HP Rudresh, Krishnamurthy D.
Number 2, madam.
This case I'm appearing for petitioner.
Yeah. 21. Yes.
Offense is, my lordship, the 498A, 50634, lordship. But respondent number
1 minute, sir. Who is the petitioner in 10279?
I'm appearing for a petitioner,
Accused number.
accused number 1.
And the petitioner in the other matter?
Petition number 2 is the mother of the first petitioner,
What is her rank as an accused?
accused mother-in-law.
Sir, accused number 1, not 2, not 3.
Accused number 1 is the husband of the accuser. Petition number 1,
Simple question, sir. Petitioner in 10279 is accused number 1 according to you.
yes, my lord.
And who is this petitioner in 2585? Petitioner 1
In
is
that case also, my lordship, that husband, lordship, he is also accused.
accused ranking in Iralva.
One, my lord.
ಇದೆ.
Accused
Accused number one, my lordship.
Both are accused number one.
Yes, my lordship. Both are
Cases are there.
Two-
different.
two cases. In two cases, that 498A has been registered.
So petitioner is the same person.
Same,
in
same
both.
person, my lordship.
Crime number one, first one is
First one, crime number is 116/2018.
18.
Ah.
For the offense,
Offense 498. 498A, 506/34, my lord.
in all, how many accused are there then?
This case, my lordship, that
Dowry
five,
Prohibition Act, my lords.
Huh?
Dowry Prohibition Act, section 3 and 4 is also.
six
there.
accused are there.
6 accused.
Yes, my lord.
Then in the second one, 2585, crime number,
2585, that two
18 of
accused,
19.
crime number,
crime number 18/2019.
the offense,
Offense not, the 498A, same.
498A,
And
354,
354A.
354A,
354,
354A,
354A,
read with 34 IPC. my lord.
34. These numbers, how many accused?
Two accused.
Two accused. my lord.
Same complainant in both.
Same complaint in both the cases.
Accused number one is the husband.
Husband.
Yes.
Lordship, that as per the complaint, the complaint is almost that is 8 pages, my lordship.
Hmm.
Looking into the
Charge
entire
sheet is not yet filed.
Filed, my lord.
charge sheet is filed.
In both the cases.
In both the case, charge sheet is filed.
Where is the charge sheet?
Charge sheet, not
Page number 66, my lords, in.
page number
10
51,
37, first matter. 10279.
page number 51, charge sheet.
Even Allah, sir, 37. Is column number 17. Column number 7, I do.
Yes, 66.
Column number 10. ಪ್ರಥಮ ವರ್ತಮಾನದ ವಿವರಗಳು ಅದಲ್ಲ ಎಷ್ಟು ಪೇಜ್ ನಂಬರ್ 55. Yes, 59.
15.
Yes.
The allegation of the complainant, all the accused have demanded the dowry prior to marriage.
Who are the other accused? 226.
Person number 2 is the mother-in-law of the complainant, and person number 3 is the father-in-law of the complainant. Person number 4, person number 2 is the mother-in-law of the complainant. Person number 3 is the brother-in-law of the complainant. Person number 4, father-in-law of the complainant. That person number 5 is also brother-in-law of the complainant. As per the complaint government, the complaint lodged on 15/12/2018, my lordship.
Yes.
Complaint lodged on 15/12/2018. And the FIR registered on 15/12/2018 based on the complaint. That place of incident that ಕೃತ್ಯ ನಡೆದ ದಿನ 19/5/2014 15/12/2018 ಅಂತ ಹೇಳ್ತಾರೆ FIR ಅಲ್ಲಿ. Crime happened from 19/5/2014 to 15/12/2018.
Yes.
At almost 4 years, lordship.
Yes.
Kindly see that page number 18, my lordship. Sorry, 19, my lord. Annexure B. Annexure B. As per the complaint governments, that all the petitioners have demanded the dowry prior to marriage, prior to engagement.
Yes.
I may be permitted to read the relevant portion of the complaint, my lordship.
Now charge sheet is already filed.
Charge sheet is already filed.
Hmm.
But they have, as per the complaint governments, they have demanded the dowry and gold ornaments prior to
Name is narrated in the charge sheet.
charge sheet, my lordship.
It is not
So,
something
all-
else.
In the event of demanded prior to marriage, that complainant side would have stopped the marriage. So it has not happened. Therefore, the intentionally she lodged the complaint as against all the petitioners. And she herself filed a divorce petition before the family court. Later on, she has withdrawn the very same petition.
MC number?
MC number 5123/2017.
5123.
5193/2017.
Filed by the complainant.
Filed by the complaint before the family court. Subsequently, she withdrawn the same.
When withdrawn?
Withdrawn in 2018, my lordship. She herself said at para number 15, my lordship. Para number 15 of the complaint. Kindly come to the page number 31. ಹಲವಾರು ರೀತಿಯಲ್ಲಿ ತಿಳಿ ಹೇಳಿದ ನಂತರ ನಾನು ನನ್ನ ಪತಿಯವರು ನನ್ನೊಂದಿಗೆ ಜೀವನ ನಡೆಸ ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ಮನೆಗೊಂಡು ದಿನಾಂಕ 21/10/2017 ನಾನು ಹಿಂದೂ ವಿವಾಹ ಕಾಯ್ದೆ ಕಲಂ 13(1) ಅಡಿಯಲ್ಲಿ ವಿವಾಹ ವಿಚ್ಛೇದನಕ್ಕಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು MC ನಂಬರ್ 5193/2017 ರಂತೆ ಮಾನ್ಯ ಫಸ್ಟ್ ಅಡಿಷನಲ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ಜಡ್ಜ್ ಕುಟುಂಬಿಕ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರಲ್ಲಿ ದಾಖಲಾಗಿರುತ್ತದೆ. ಪ್ರಕರಣವು ಮಧ್ಯಸ್ಥಿಗಾಗಿ ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ಈ ಮಧ್ಯಸ್ಥಿಕೆ ಸಮಯದ ನನ್ನ ಪತಿಯವರು ತನ್ನ ಎಲ್ಲ ಕೃತ್ಯಗಳಿಗೆ ಕ್ಷಮೆಯಾಚಿಸಿ ತನ್ನ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ತಿಳಿಸಿರುತ್ತಾರೆ ಮತ್ತು ಇಂದಿನ ಎಲ್ಲಾ ವಿಷಯಗಳನ್ನು ಮರೆತು ಪ್ರತ್ಯೇಕವಾಗಿ ಮನೆಯನ್ನು ಮಾಡಿ ನಾವಿಬ್ಬರೇ ಜೀವನ ನಡೆಸುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಈ ಬಾರಿ ನಾನು ನನ್ನ ಪತಿಯವರ ಚಾಣಾಕ್ಷಿ ತಂತ್ರಕ್ಕೆ ಒಳಗಾದಂತೆ ಪ್ರಯತ್ನಿಸಿದೆ.
Yes.
That later on, that husband has filed a divorce petition before the family court.
MC number?
MC number 4977/2018. 18.
That is also family court Bangalore.
Family court Bangalore.
Huh.
And she filed a maintenance petition before the Bangalore family court, that the trial court has ordered 25,000 rupees maintenance every month. The same was challenged by the husband before the High Court in writ petition number so and so. That in the High Court that
That is 125 proceedings.
not 125 under section 25, my lords.
Hindu marriage.
Hindu marriage. She is working as a BMTC conductor in Bangalore itself.
A1 is working as? A1?
A1 is working as is a tailor, is doing embroidery work at a small company, not a regular job. Only on the
Maintenance amount granted?
25,000 rupees was granted. The trial court has ordered that subsequently the same was challenged by the husband before the Honorable High Court in writ petition number so and so, that in the writ petition that observed that wife is working on the ground that maintenance order is that rejected, my lordship.
WP number?
WP number. I will give, my lordship. I have I will submit.
So that WP was allowed?
WP was allowed. And in the page, at page number 4 of the complaint, my lordship, that she has stated that she has taken to the astrologer.
Yes.
For the puja's sake. It has happened in 2015.
Yes.
In the complaint at page number 25, that para 10, my lordship. At para 10. Based on this complaint, one more complaint has been filed by the wife before the Maddur police station under section 498A and 354. Once again, they registered a complaint under section 498A.
Earlier, which police station? 116?
At Maddur police station.
Maddur police.
Maddur police station.
Why there are two complaints, 498A?
Deliberately she lodged a complaint first before the Basungudi Women Police Station, then subsequently she lodged a complaint before the Maddur Police Station under section 498A.
No, both the criminal cases are before the same police station or different?
Different police station.
Yavdu first one ellidu?
First one filed it before the Basungudi Police Station, my lordship. It is in criminal petition number 1027. ಈಗ ತಾವು ನೋಡ್ತಾ ಇರೋ criminal petition ಅಲ್ಲೇ ಇದೆ ಅದು. In criminal petition number 2585, that again she lodged a complaint under section 498A and 354.
FIR was registered on?
FIR was registered, charge sheet also filed, my lord.
When FIR was registered?
12/1/2019. Maddur Police Station.
12/1?
12/1/2019.
12/1/2019. After the lapse of 4 years, she registered a complaint before the Maddur police station.
Yes.
That incident, as per the FIR, incident happened in from 19/5/2014 to 4/2/2015. But she lodged a complaint on 12/1/2019. So it is a deliberate and concocted complaint. She could have lodged a complaint that the very next day itself. Instead of that, she lodged a complaint after the lapse of 4 years. In the first complaints, in the first FIR also 498A registered. In the second FIR registered by the Maddur police station, same that the section also mentioned.
Similar allegations in both the complaints?
Order.
Similar allegations in both the complaints?
Yes, my lord. Similar allegations in both the complaint.
Why the second complaint then?
Deliberately she registered.
Give me the details of this MC petition and WP.
WP number I will give.
ಏನು ಪ್ರಿಪೇರ್ ಆಗಿ ಬರೋದಿಲ್ವಾ?
ಇಲ್ಲ ಇದೆ I will give.
ಇದ್ಮೇಲೆ ಎಲ್ಲ ಹುಡುಕೋದು ಹಿಂದೆ ಮುಂದೆ.
We make one submission, my lords. Offences are not similar in both the petitions, my lords.
I'll come back.
Yes, come back.
ಏನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅದು ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ಹೇಳೋದು ಅಷ್ಟೇ. Yes.
With regards to the allegations, my lords, the offences registered are the common offences, my lords, with regards to 498A, my lords, as to the husband, my lords, and his relatives. But with regards to other offences, my lords, in 2585, my lords,
498A is invoked only against husband. Not against any-
and his relatives also. In
Why two complaints?
that is my, because my lords, in what happens is, my lords, the husband takes the wife to a astrologer, my lords, to perform certain puja where
You married accused number 1 on 19/5/2014.
please,
How long you stayed with him?
4 years, my lord, until 2018, my lords.
Which date?
8, my lords. It is, I do not have the date, my lords. But with regards to why she has,
At
there's a
least
period-
month ಇದೆಯಾ, year ಇದೆಯಾ?
2018. 18 December. That's when she files the first FIR, my lords. 18 December.
So since 2018, she is not residing with him. December 2018.
Okay.
She is residing separately.
Yes, what she states, my lords, is that why she has not taken legal recourses, my lords. It's in her complaint itself, in page number 15 of criminal petition 2585, my lords. In paragraph 4, she categorically states, my lords, that all these days I did not seek recourse to the aforementioned act of the above named for the simple reason that the same could jeopardize my marital life. And once the husband has kicked her out of the house, she has gone and filed this complaint, my lords. And in the same complaint, my lords.
No, first complaint was filed when you came out of the house,
2018.
after coming out of the
Out of the-
matrimonial house.
Out.
Then why you have not included all those things? Why the second complaint?
So second complaint is because, my lords, the Basangudi police station itself, they state that the offenses occurred in Maddur with regards to the.
Maybe you could have sought for transfer of the crime number.
Because they have suggested that I have gone there and filed another FIR with regards to two accused person. One is the husband and
Oh,
the
even according to you, the same allegations in both the FIRs.
only with regards to 498A. The other allegations are different, my lords. In crime number 18 of 2019, 498A, 354, 354A and 34. In crime number 116 of 18, which is registered in Bangalore City, my lords, in that allegation is 498A, 506, 34 and Dowry Prohibition Act under section 3 and 4, my lords. Only 498A is common, my lords.
What is the allegation to
Equation
invoke
numbers.
354?
WP numbers.
That is it, my lords. Page number 14, my lords. In paragraph 3, she states, my lords, that she has been taken to the astrologer where he assaults her.
Who?
The astrologer.
He is also an accused.
He is also an accused in accused number 2, my lords, in 2585. In 2585, the relatives are not made an accused, my lords. The only is accused persons are the husband and the astrologer, my lords. In the other petition, the husband and his family members are made parties. My lords. And this astrologer is in Madhur, my lords, and that is why the complaint has been filed in Madhur. In paragraph 3, my lords, page number 14, he categorically states in the complaint, my lords, that while we were there, Mr. Mohandas started to touch me inappropriately in front of my husband and told me that Ninna Kalguna Chanagilla, and that because of me, my husband is going to die a sudden death at a very young age, and after that I am going to be a prostitute and bring a bad name to my marital home, and all of this is going to happen because I have certain dosha in my kundli. He categorically states that, my lords, that the astrologer has been touching her inappropriately, and the husband had forced her to go to that place, my lords. And also this happens in the presence of husband, my lords.
Yes. What about the first one?
I got the 2 writ petition number, my lord.
Tell me.
Yeah, that I have given. Writ petition.
ಹೇಳ್ಬಾರ್ದಾ sir? ಯಾಕೆ ಹೀಗ್ ಮಾಡ್ತೀವಿ?
Yes, yes, I'm sorry, my
Come
lord.
to page number so and so, para number so and so. ಅದನ್ನ ಇದಾಗಿ ಹೇಳಲಿಕ್ಕೆ ಗೊತ್ತಾಗಲ್ಲ ನಿಮ್ಗೆ.
No, that subsequent, after the soon after.
Number ಅಂತ ಕೇಳಿದ್ರೆ
Sorry, no,
ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ.
no, that writ petition number.
Practice
WP number was not mentioned in both the criminal petitions.
Can you not tell me?
Yes.
ಅದನ್ನ ನಾನು ನೋಡ್ಕೋಬೇಕು ಮತ್ತೆ. This is the assistance you are giving. Why your services are engaged?
Very sorry, my lord. I'm apology.
From the beginning, I am seeing.
No, I'm apology that what has happened, that both the writ petition.
Apology, sorry. Now, even now you don't know the writ petition number.
I got it from the net, my lords.
Your apology will not serve any purpose.
Yes.
On the other hand, you are directing the court, come to page number so and so, para number so and so. You look here, you look there. Writ petition number, I am having it. Is it the way of addressing the argument? You are not in a position to say the facts of the case in brief. Facts ಏನು ಕೇಳಿದ್ರೆ, yes, I will read the entire 8 or 11 pages. At whose cost? ಇದು ಆಫೀಸ್ ನಲ್ಲಿ ಏನು ವರ್ಕ್ ಮಾಡಲ್ಲ. ಒಂದು ಏನು ಅಂತ ಕೇಳಿದ್ರು ಓದೋದು, ಇಡೀ ದಿನ ಓದೋದು.
That 2 writ petition numbers was not mentioned in the amendments of the.
I understand.
Yes.
Can you not tell me now? When it is not mentioned, when you are not having any particular, why you raise such grounds? Yes. Anything else?
No, my lords. With regards to the complaint in 116, my lords, she also alleges that dowry has been sought, my lords. And
Why there was delay?
Delay is because, my lords, the only reason is, my lords, she did not want to jeopardize her marital life. Once she was thrown out of the house,
Sir,
she
you
had.
are alleging 506 also, 3 and 4 also. The demand for dowry was before marriage. They threatened to stop the marriage.
Please,
Then everything was set right. You married happily.
but after marriage also.
Where is the question of making allegations?
No, what happens is, my lords, after, even after marriage,
Hmm.
they state
After
that.
marriage, I understand. But the allegation is that before marriage, they threatened,
Or is
they demanded, they
After-
received, threatened. Why you should agree to marry with all such difficulties?
That is the only aspect.
After
of the-
4 or 5 years, see, Dowry Prohibition Act, cruelty.
Yes, that is because,
Is it
my
the
lords,
spirit of law?
as a woman, my lords, she had no other recourse apart from.
So she
staying
was
in the-
compelled to marry.
my lords,
She was compelled to marry.
She has not alleged anything.
Then
But. as
is she a child?
No. she
Then?
made it.
What justification you can have?
The only aspect is, my lords, that once she has thrown out of the house, only then she has.
Then she
taken
started
pers-
making allegations.
Not, I mean, that is what has happened, my lords, factually speaking. that
Sir,
is-
please justify your contention
Please.
regarding the demand made for a dowry at the time of engagement. Before marriage, what justification you can have?
Because to that, I do not have any justification. for
That is what I am saying. After marriage, I understand.
Please, my lords. But they did not stop even after.
She was fair to say no for the marriage.
Please, my lords.
She has not done so. Yes,
My lords, there are allegations of 354, my lords,
Mm.
beyond 498A.
Mm.
It only happened when the Jyotishi touched her inappropriately, my
Mm.
lords. Based
Yes.
on that allegation, it is the duty of the husband to protect her, my lords.
I understand that. What about the first one? 116 of 18,
Yes, my lords.
against all the family members.
Yes, my lords. There is no specific allegation against all the family.
So I will allow this 10279.
Please, my lords.
I'll dismiss this 2585.
Please. my lords.
Yes. Over.
So far as that.
10.
One submission.
9 of 2021. The petitioners being accused numbers 1 to 5 are seeking to quash the criminal proceedings initiated against them by respondent number 2 for the offense punishable under section 498A or 6, every section 34 of IPC and under section 3 and 4 of DP Act. Third, so then counsel for the petitioner contended that the petitioners are arrayed as accused number 1 to 5. Accused number 1 is the husband, 2 is the mother. The mother of accused number 1, 3 is the brother, 4 is the father, and 5 is the brother of accused number 1. They are all falsely implicated in the matter without any basis. The marriage between accused number 1 and respondent number 2 was performed on 19/5/2014. Till 4 years, there was absolutely no allegations against the petitioners. However, the first information was going to be filed on 19/5 on fifteen 12/2018, alleging that before marriage, the petitioners have demanded dowry and received the same, threatening that they will cancel marriage. The first information runs into several pages, but the allegations filed without any details. Then counsel further submits that the two had filed MC number 5193 of 2017 before the family court at Bengaluru, taking resolution for marriage with accused number 1. But subsequently, during 2008, the same was withdrawn. Accused number 1 filed MC 4977 by 2018, seeking divorce before the family court at Bengaluru. The same is still pending consideration. And counsel also submitted that the complainant had sought for maintenance under the provisions of Hindu Marriage Act, and the trial court had granted her the maintenance. When the said order was challenged before this court, the said order granting maintenance was set aside. Therefore, it is clear that the respondent number 2 is bent upon in harassing the petitioners. The petitioner. Next paragraph. And the counsel also submitted that one more complaint alleging commission of the offense under section 498A was made by registering the first information in crime number 18 of 2019 of Madhur Police Station for offense under section 490 Madhur Police Station. This shows that repeatedly the respondent number 2 is filing similar complaint, making similar allegations. Continuation of the criminal proceedings against these petitioners would amount to abuse of process of law, hence praise for allowing the petition. Per contra, learned counsel for respondent number 2 opposing the petition submitted that since from the date of marriage, the petitioners were committing the offense. Only to save the marriage, the informant kept quiet till December 2018. She has in detail stated about the offense committed by the petitioners. When there are prima facie materials to constitute the offense, the petition is liable to be dismissed. Accordingly, praise for all with dismissing the petition. Next paragraph. We made additional SPP opposing the petition submitted that the offense alleged in crime number 116 of 2008, 18 of Paswangudi Police Station, and crime number 18 of 2019 of Madhur Police Station are two different offenses. In crime number 116 of 2018, filed by respondent number 2, the offense under section 498A and 506, that is section 34 of IPC, and also under 3 and 4 of DP Act is made. However, the allegation regarding a demand for dowry and acceptance of the same before her marriage. Since there is allegation regarding the commission of the offense under section 498A and 506, the petition is liable to be dismissed. Reduce the materials, point for consideration. My answer to the point in the affirmative for the following. The admitted facts of the case are that respondent number 2 married accused number 1 on 19/5/2014. The first information came to be filed on 15/12/2018, which was registered in crime number 116 of 2018 of Baswangudi Police Station for the offense punishable under section 498A, 506, read with section 34, PC, and under section 3 and 4 of DP Act. According to the informant, the petitioners have demanded dowry prior to the marriage and accepted the same. They have threatened to cancel. Respondent number 2 is a major, and there was absolutely no compelling reason for her to accept the demand for dowry, pay the same, and to get married to accused number one. When once accused number one, when once respondent number two accepted the demand and paid it happily, and thereafter married accused number one to lead the marital life, I do not find any justification for her to make such allegations after 4 long years. 4 long years. Even though then 506 of IPC is also invoked, I do not get sufficient support to constitute the offense under the said provision of law. Next paragraph. It is pertinent to note that admittedly, the respondent number 2 registered crime number 18 of 2019, Madur Police Station, again invoking section 498A of IPC along with other penal provisions. Under such circumstances, the present petition where the similar penal provision, where similar allegations are made to contend that respondent number 2 was treated with cruelty and the offense under section 498A was committed by accused number 1. Accused number 1. Therefore, I am of opinion that the initiation of criminal proceedings in crime number 116 of 2018 of Proceedings Police Station is a sheer abuse of process of law, and the same is to be quashed. Accordingly, I answer the above point in the affirmative. Petition is allowed, so on. Next, in 2585 of 2021. Petitioners being accused number 1 and 2 are seeking to quash the criminal proceedings initiated against them. Third, so on. The counsel for the petitioner contended that respondent number 2 had already registered crime number 116 of 2018 of Proceedings Police Station for having committed similar offense under section 498A of IPC. But again, in 2019, the present complaint was came to be filed. There is absolutely no basis for registering the second complaint, when admittedly respondent number 2 was residing separately since December 2018, there is no basis for registering the present complaint. He further submitted that respondent number 2 had filed MC 1593 of 2017 before family court at Bengaluru, seeking dissolution of her marriage with accused number 1. But the same was came to be withdrawn during 2018. Accused number 1 filed MC number 4977 of 2018, seeking dissolution of marriage before family court at Bengaluru, and the same is pending consideration. Even though respondent number 2 had sought for grant of maintenance under the provisions of Hindu Marriage Act, and the maintenance was granted by the trial court, the said order was set aside by this court in the writ petition. Filing and maintaining 2 parallel complaints making similar allegations is nothing but abuse of process of law, and hence the place for allowing the petition. Per contra, learned counsel for responding number 2 opposing the petition submitted them. The allegations made in crime number 18 of 2019 of Madur Police Station is entirely different, and section 354 and 354A of IPC are also invoked against accused number 1 and 2. Accused number 1 is the husband and accused number 2 is an astrologer who committed the offense punishable under 354 and 354A of IPC by inappropriately touching the body of respondent number 2 under the guise of making some puja and setting right her kundali. Accused number 1 was very much present along with accused number 2, and he never protested nor protected respondent number 2. Therefore, specific allegations are made against accused number 1 and 2 to constitute the offense. There are no reasons to quash the criminal proceedings, hence the place for allowing dismissing the petition. Learned additional SPP supporting the contention of the learned counsel for responding number 2 submit that since prima facie materials are, since serious allegations are made against accused number 1 and 2 to constitute the penal offense, the petition is liable to be dismissed. Accordingly, place for dismissal of the petition. Peruse the materials. My answer to the point in the negative for the following reasons. Respondent number 2 filed a first information making specific allegations regarding commission of offense under section 498A from 19/5/2014, that is from the date of marriage till 4/2/2015. She also stated that accused number 1 had taken her to accused number 2, who posed himself as an astrologer and inappropriately touched her body and committed the offense under section 354 and 354A of IPC. When complained by respondent number 2, even accused number 1 warned her not to oppose accused number 2, and thereby he joined hands with accused number 1 in committing the offense. The allegations against accused number 1 being the husband and 2 who posed himself as an astrologer is of serious nature. Specific allegations are made against both the accused, and under such circumstances, it cannot be said that the criminal proceedings is liable to be quashed. Next part. Admittedly, respondent number 2 has filed a similar complaint, registered in crime number 116 of 2018 of Kaswari Police Station against accused number 1 to 6, that is her husband and his family members, alleging commission of the offense punishable under section 498A, 506, read with section 34 of IPC, and under section 3 and 4 of Dowry Prohibition Act. There, the offense said to have been committed from 19/5/2014, that is from the date of marriage, till the date of filing the complaint, that is 15/12/2018. On facts of the case, the criminal proceedings in crime number 116 of 2018 is quashed as per order passed in criminal petition number 10279 of 2021. In the present case, by filing the second complaint, the allegation regarding cruelty is made against accused number 1, invoking section 498A of. It is pertinent to note that accused number 2 is a stranger to the family And he claims he posed himself as an astrologer. And specific word to constitute the offense under 354 and 354A of IPC is made by the informant. Looking to the nature and seriousness of the allegations made against accused number 1 and 2 in the present case, I am of the opinion that it is not a fit case for quashing the criminal proceedings. Hence, answer they were point in the negative, proceed to first of all. 21 is allowed, 21.1 dismissed.
14 settlement, serial number 22, Homi Thomas, Jagdish.
Was responding to and complaint before the court below.
Hearing for the petitioner, my lord.
Yes.
On base of the
My lords, a kind submission, my lords. The offences are punishable under section 504, 420, 465 and 506B of IPC, my lords. 465 and 506B are non-compoundable, my lords.
465 and
506B are non-compoundable, my lords.
kindly see the complaint. FIR someone substance is that malada.
ಈಗ ಏನು on merits argument?
ಇಲ್ಲ ಸ್ವಾಮಿ ಅದು affidavit ಹಾಕಿದ್ದೀನಿ. I have no objection to allow the complaint. I filed the affidavit of the complaint respond number 2 lordship on malada. On 25th July, malad. In that affidavit, malad, the complaint has no objection to allow the criminal petition by quashing the private complaint pending before the court below. The affidavit of the respondent number 2 complaint, malad. The state of the dispute, civil dispute, complaint is that
Criminal case ಯಾಕೆ ಹಾಕಿದ್ದು?
malad,
Why you filed a criminal complaint?
on the ground that malad,
ಗೊತ್ತಿರ್ಲಿಲ್ವಾ civil dispute ಅಂತ?
now they amicably settled it.
Huh?
Amicably settled the matter.
Amicably settle ಆದ ಕೂಡಲೇ civil dispute ಆಯ್ತು. ಮೊದಲು criminal dispute.
Allegations are, my lords, they have forged the sale deed, my lords, dated 35/1995, my lords. Complainant by saying that the father of the complainant has executed the sale deed, my lords, in favor of these accused persons, and they have abused and threatened to take away the life of this complainant.
My lord,
Vacate the house.
whatever allegations has been made, nothing has been proven. That is why we filed this petition.
No, to prove the matter, the trial is to be held.
Yes, my lord.
That stage has not
Yeah,
yet
no,
come.
then there was a negotiated settlement.
It's only the stage of allegation. Go for trial, they will prove it.
No, they cannot prove because we are,
No, you cannot jump to the conclusion, sir.
yes, my lord.
It is the duty of the prosecution to prove it.
Yes, my lord. No, they themselves, both the parties came for negotiation.
Be two provisions of law are non-compoundable offenses.
Yes.
There is no whisper in the affidavit.
Right.
What is required? When you want to compound the offense, when it is non-compoundable. Basic things ಮಾಡಲ್ಲ.
Permission of the court.
with permission of
Compounded, incompounded. What is to be done?
permission of the court.
ಯಾರು ಕೇಳ್ಬೇಕು? ಯಾಕೆ ಕೇಳಿಲ್ಲ? ಮೆಮೋ ಮೂವ್ ಮಾಡ್ತೀರಿ, ಅವಾಗ ಮಾಡಿದ್ದೆ, ಇವಾಗ ಮಾಡಿದ್ದೆ, ಲಿಸ್ಟೇ ಆಗಿಲ್ಲ. ಒಂದು 5 ನಿಮಿಷ ಕೂತು ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಇದ್ರೆ ಎಲ್ಲದೂ ಗೊತ್ತಾಗುತ್ತೆ. ಇಬ್ರು ಇದ್ದೀರಿ ಮತ್ತೆ. Why that is not made?
Correct.
Then what is to be done now?
I will file, sorry.
ಅಷ್ಟೇ, pray for time. ಮತ್ತೆ ಮುಂದೆ ಮತ್ತೆ ಮೆಮೋ ಮೂವ್ ಮಾಡಿ, ಮತ್ತೆ ಲಿಸ್ಟ್ ಮಾಡಿ. Counsel for respondent number petitioner and respondent number 2, pray for time. Next.
Hearing three groups, serial number 23 Arjun, 24 Prajwal, Vinayak Abhi,
My lords, I am for the,
Have it on next Monday, my lord.
Next.
my lords, I am for the complainant in. On last occasion, your lordship has directed to secure records of the orders in coordinate bench. I like to place the
What is that
order
order?
wherein the accused number 3, the proceedings against accused number 1 was discharged, wherein it is categorically observed in para 14 at page number 14, Your Honor.
No, this was filed by accused number?
Accused number 3. The present petition is filed by accused number 3.
No, sir, this order.
The order is against accused number 1, wherein the proceedings against accused number 1 was quashed in the middle of the paragraph, Your Honor.
Why there are 2 writ petitions?
There were 2 checks issued against for discharge of liability for the pending dues against the supply of aqua products. Complainant is the partnership firm carrying on the business of sale of aqua products.
How many accused are there?
There were 3 accused.
Who are they?
Accused number 1 is the Janata Sonak partnership firm, which is the respondent number 2 in this present writ petition. And accused number 2 is the Koduru Rama, as against the proceedings were quashed. And accused number 3 is the present petitioner, Your Honor. And
see, there are 2 complaints.
yes,
There are 2 complaints.
yes, yeah.
PCR numbers?
PCR number 630 of 2018.
630?
Of 2018.
Huh.
And 629 of 2018.
Both under 138.
Yes, yeah.
In respect of same checks?
In respect
Two
of
different
different
checks.
checks, 2 different checks.
2 different checks.
2 different checks. PCR 630 is with respect to check number 198359. Dated 23/4/2018. Drawn on Indian Bank, Nellore branch.
Then?
And PCR 629 of 2018 is with respect to check number 198360. Dated 23/4/2018. Drawn on Indian Bank, Nellore branch. The said checks were dishonored on 24.
Now, who are the petitioners? What is petition copy?
Petitioner is the accused number 3.
Accused number 3.
Accused number.
Who is accused number 1?
Accused number 1 is respondent number 2, Sonak company. It's a partnership firm.
Now you are representing whom?
I am representing respondent number 1, complainant.
यार petitioner यार इधर है.
Prajwal P.
Why there are 3 accused in 138 in an act case? Generally, there will be 1. Why there are 3?
The check was issued by the partnership firm, and the accused number 3 is the signatory of that check.
Accused number 1,
Accused number 1 is the partnership firm.
who is A2?
A2 is Koduru Rama.
You know, what is his role?
She is also
Why
the
is there a-
partner.
There are two partners, only two partners.
Two partners.
Then. The criminal proceedings against accused number 1 in both the cases are quashed,
Accused number 2 is quashed.
not an accused number 1.
Not accused number 1.
Then.
The petitioner is before this honorable court to quash the
He is the
proceedings.
signatory. He is the signatory to the check.
He is signatory to it.
ಅದು ಒಂದೇ ಮಾಡಿದಾರ? Has filed only one petition?
2 petitions.
Two ಇದೆಯಾ?
24412 and 24413.
2441. ಇಲ್ಲ, ಎಲ್ಲಿದೆ? ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಇಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಒಂದು. ಮತ್ತೆ? Today only one matter is listed.
Yes.
Lord, may I submit?
Hmm.
Really, Lord, the company is the, Lord, I mean, partnership is the first accused. The other two persons are partners. In the legal notice, my Lord, our complaint, Lord, we didn't specifically say, my Lord, accused number 2 is also vicariously liable. Accused number 3 is the signatory to the check. My Lord, that principle will not apply to accused number 3. Accused number 2 filed a writ petition, and my Lord, on that ground it was quashed. In the Lord, in the order also it is mentioned, he is the signatory to the check. And it can be proceeded against accused number 1 and 3. Para page 14. Lord, after allowing of this writ petition, my Lord, the accused number 3 has also approached this honorable court by filing the present petition.
Yes.
Lord, in Lord, in the judgment, my Lord, in WP filed by accused number 2, my Lord, the several cases were relied on. One of the cases is, my Lord, KK Ahuja versus VK Vora and another 2009-10 SEC, page 48. My Lord, in that judgment, para 27. My Lord, it specifically said, my Lord, in the case of a director or an officer of the company who signed the check on behalf of the company, there is no need to make a specific government that he was in charge and was responsible to the company for the conduct of the business.
ಎಲ್ಲಿದೆ ಅದು?
My Lord, 2009-10 SEC.
No, that was not referred to here. It is referred in this order.
ಮಾಡಿದ್ದಾರೆ ಅದನ್ನು ಅದರಲ್ಲೂ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಪ್ಯಾರಾ 8 page 9 ಅಲ್ಲಿ.
Why you are relying on this? Now accused number 3 is the signatory to the check.
Check, my Lord, that is what this judgment says, my Lord.
Yes.
When my Lord, the director of the company, officer of the company who has signed the check, my Lord, they are directly liable. There is no need to make a specific allegation.
Which is the paragraph?
Paragraph 27. Page 61, paragraph 27. Lord, the position under section 141 of the act can be summarized thus. Lord, second one, in the case of a director or an officer of the company who signed the check on behalf of the company, there is no need to make specific government that he was in charge of and was responsible to the company for the conduct of the business of the company, or make any specific allegation about consent, connivance, or negligence. The very fact that the dishonor check was signed by him on behalf of the company would give rise to responsibility under subsection 2 of section 141.
Yes.
Therefore, my Lord, here she is a signatory.
So good. the petition being accused number 3. In CC number 2127 of 2018, on the file of the learned third additional civil judge in JMFC UP, is seeking to quash criminal proceedings initiated against him in the ends of justice. Learned counsel for the petitioner is absent, no representation. Heard learned counsel for respondent number 1. Here is the materials under. Learned counsel for the petitioner and respondent number 2 are absent under. Heard learned counsel for respondent, here is the materials under. Respondent number 1 has complainant filed PCR, the private complaint in PCR number 630 of 2018 against accused number 1 to 3, alleging commission of the offense punishable under section 138 of an act. It is specifically stated that accused number 1 is a partnership firm and accused number 2 and 3 are its partners. It is the contention of the complainant that accused number 3, who is the petitioner hearing, is the signatory to the check bearing number check in question dated 23/4/2018 issued towards legally recoverable debt. Now, next part. Now it is the contention of the petitioner that unless it is specifically stated by the complainant in the complaint that the petitioner is responsible for day-to-day affairs of the firm as required under section 141 of NIA, she cannot be arraigned as accused. Learned counsel, next part. Learned counsel for respondent number 1 places reliance on the decision of the apex court in KK Ahuja versus VK Aura and another 2009 part 10 SCC 48, wherein the Honorable Apex Court, after considering its various earlier decisions, summarized the position under section 141 of NI Act. While so summarizing, it is categorically held that when a director or an officer of a company signs the check on behalf of the company, there is no need to make a specific averment that he was in charge of or was responsible to the company for the conduct of the business or make any specific allegations about consent, connivance, or negligence. It is further held that the very fact that the dishonored check was signed by him on behalf of the company would give rise to responsibility under subsection 2 of section 141. Thus, the position of law is very well settled, which is an answer to the grounds raised by the petitioner in his petition. When admittedly, the petitioner being respondent number 3 is the signatory to the check in question, the criminal proceedings against him is not liable to be quashed. Next part. The counsel for respondent number 1 placed on record the order dated 1/2/2019 passed in WP number 50829 of 2018 and 50834 of 2018 and contended that these petitions filed by accused number 2, who was one of the partner in the firm, came to be allowed on the ground that he is not the signatory to the check in question, but was only a partner in the partnership firm. Therefore, quashing the criminal proceedings against accused number 2 will not inure to the benefit of the present petitioner, who is admittedly the signatory to the check. The coordinate bench of this court, in the order dated 1/2/2019, categorically observed as under undisputedly, the firm was represented by accused number 3, and it is she who has signed checks which have been since dishonored, against which proceedings have been initiated by the complainant. However, first respondent would be at liberty to proceed against second respondent oblique accused number 1, as well as third respondent oblique accused number 3 in the pending proceedings, and no opinion is expressed in that regard. In that regard, adu para number 11 anta haki dash anta haki last ಗೆ. Thus, quashing of the criminal proceedings against accused number 2 will not in any manner help the petitioner to seek similar order. Therefore, I am of the opinion that the petition is liable to be dismissed. Accordingly, I answer. Dismissed.
Lord, there is one more matter.
Is
ಇನ್ನೊಂದು
that-
ಕ್ಲಬ್ ಆಗಿಲ್ಲ 24413 of 2019
ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಯಾವ್ದದು? ಅದು ನೋಡಿ ತಗೊಳ್ಳಿ, ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ. ನೆಕ್ಸ್ಟ್.
ಮತ್ತೊಬ್ರು.
Serial number 25, submitted, Jaikar Shetty.
I appear,
Yes, Arbity.
I appear for the petitioners in this matter, my lords. My lords, a petitioner was an employee under the
ಇದ್ಯಾವ್ದು? Yes.
My lords, the petitioner was an employee of the KSRTC department, my lords. Based on a source report, my lords, proceedings was started under the Lokayukta Act, my lords. And that particular predicate offense has been quashed by this coordinate bench of this honorable court, my lords. If I may kindly pass the memo along with the documents, my lord.
Sir, who is the petitioner? What is the relief claimed?
Petitioner was an employee of the KSRTC department, my lords. He was a director.
Yes.
And petitioner number 2 and 3 are the wife and the son of the petitioner number 1, my lords.
They are also accused number 2 and 3.
Please, my lords.
Huh.
My lords, what has happened, my lords? Based on a source report, my lords,
Yes.
proceedings were started under the Prevention of Corruption Act, my lords. That was only against the accused number 1, my lords. Based on which this particular proceedings was initiated under the PMLA Act, my lords. Now, my lords, the proceedings under the Prevention of Corruption Act, my lords, that has been quashed by this honorable court, my lords, in another
Okay.
matter. If I may kindly pass the memo along with documents.
So what?
My lords, kindly peruse page number.
That under PC Act, crime number?
My lords, crime number 92 of 2012, my lords.
Huh?
2012, my lords.
Crime number?
92.
92 of
92 of 2012.
12. Which police station?
My lords, it was registered by the Superintendent of Police, Lokayukta Police, my lords.
ಲೋಕಾಯುಕ್ತ
Lokayukta Police.
ಅದು ಏನು ಊರು ಕೇರಿ ಏನು ಇರೋದಿಲ್ವ ಅದಕ್ಕೆ?
Then, my lords, a charge sheet was filed on 18/12/2012, my lords. Based on that charge sheet, my lords, this PMLA proceedings were started, my lords. Based on that particular final report, my lords.
Yes.
Now, my lords, if my lords kindly peruse the documents I just passed.
Accused number 2 is your
5, my lords.
wife. 3
Son.
son.
3 sons.
Where is the order quashing the criminal proceedings?
Page number 1, my lords. The operative portion is at page number 6, my lords.
Page number
6, my lords. Paragraph 12, my lords. It is important, my lords. I'm reading it from the 3rd line, my lords. If I may read, my lords.
para number.
Sorry, my lord.
Para number.
Para number 12, my lords. It's at page number 6, my lords.
Yes.
My lords, 3rd line, my lords. It is important to know that the income tax returns filed by the wife, which form part of the charge sheet and are not disputed by the respondent Lokayukta, clearly establish that the income of the wife for the period from 2001 to 2012 was around 1 crore 91 lakhs, my lords, which was not considered, my lords, which is why there was disproportion, my lords. And my lords, accordingly, there is absence of prima facie evidence to support the charge sheet against the petitioner. This court, in excess of the inherent power, my lords, of 482 CRPC can intervene and prevent the abuse of process of law. Hence, the petition was allowed, my lords. If my lords see the second para, my lords, it says the proceedings under CC number 587 was quashed, my lords. And also, my lords, if you kindly peruse page number 7 and 8, my lords, there doesn't lie any appeal against this particular order, my lords.
Not challenged.
It is not challenged.
Still time is there, ma'am. August 31/5
May
of the
2024 order.
still time is there.
How many days?
90 days, my lord, to file as well.
May 31st. August end
June,
ವರೆಗೆ.
July, August.
Hmm.
August and
You propose to challenge that?
okay.
Yes, my lord, we have given opinion to file the appeal.
Then
Well, it's
It is under process, my lord.
Till the end of August, they will have to, at least.
well, it's already there is an interim stay of the proceedings, my lords, in this particular.
that will be there, sir. That will be there. What should happen tomorrow, in the appeal, if it is set aside? ನೋಡೋಣ 1 month ಆದ್ಮೇಲೆ ಬನ್ನಿ.
At least before filing, time is still there, even after expiry of.
ಅದನ್ನ
90
ಮೊದಲೇ
days.
ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು. ಅದನ್ನ ನಾವು ಕೇಳಿದ್ಮೇಲೆ ನೀವು ಹೇಳ್ಬೇಕಾ? You could have made the submission at the beginning.
Oh, no. When he submit me, I can't.
Okay. When he relies on that order, can you not say that it is proposed to be
Immediately,
challenged?
immediately after his, this one I. submitted.
ಸೊ ಅಲ್ಲಿವರೆಗೆ ನಾವು ಕಾಯ್ಬೇಕು, ಇದನ್ನೆಲ್ಲ ಕೇಳ್ಬೇಕು, ಬರ್ಕೋಬೇಕು, ಆಮೇಲೆ ನೀವು ಹೇಳ್ತೀರಿ ನಾವು ಅಪೀಲ್ ಮಾಡ್ತೀವಿ, ಅಡ್ಜರ್ನ್ ಮಾಡಿ.
ಅಲ್ಲ ನಾವಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರು.
ಯಾರಾದ್ರೂ ಇರ್ಲಿ ಸರ್, ಏನು Pay for time, next time. ಸ್ವಲ್ಪ ಕಾಮನ್ ಸೆನ್ಸ್ ಬೇಕು ಸರ್. Why the time of the court is wasted?
ಇಲ್ಲ ಕೆಲವೊಮ್ಮೆ ನಾವು ಮಧ್ಯದಲ್ಲಿ ಮಾತಾಡಿದ್ರು ತಪ್ಪಾಗಿ ಕಾಣುತ್ತೆ. ಹಾಗಾಗಿ ನಾವು ಸ್ವಲ್ಪ ಕಾಯ್ತೀವಿ.
ಆಯ್ತು ಬಿಡಿ, ರೇಟ್ ಇದೆ.
My lords may fix a date in the first week of
Unnecessarily
September.
ಮಾತಾಡಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಹೇಳ್ತೀವಿ. ನೆಕ್ಸ್ಟ್.
May I request your lordships to fix a date in the first week of September?
1 month ಆದ್ಮೇಲೆ. ನೆಕ್ಸ್ಟ್.
September 26th.
ಸೆಪ್ಟೆಂಬರ್.
First week of September.
ನೆಕ್ಸ್ಟ್.
Grateful, my lords.
ಇದನ್ನ ಅದಕ್ಕೆ ಹಾಕಿ.
September 27th.
I apologize, but the interim order may be extended on the last.
ಇದೆಯಾ? Last date
Extended.
not extended.
Inadvertently, it did not get extended. It was extended from time to time, all the time. In the last occasion.
File an application. Next.
My lords,
September 27th, B.S. Sachin.
my lords, I appear for the petitioners, my lords.
In this case, I am appearing for my lord, complainant response.
My lords, I'm challenging PCR number 225 of 2020, my lords, wherein accused number 2 is petition number 1, my lords, accused number 3 is petition number 2 herein, my lords, accused number 1 is no more, my lords. My lords, while filing the private complaint, my lords,
What are the offense alleged?
my lords, the offense allegations are 406, 420, 465 and 468, my lords.
Yes.
My lords, while filing the private complaint, my lords, firstly, my lords, they have not complied with the Priyanka Srivatsa guidelines, my lords. That is promise. There is no affidavit, my lords, to the private complaint filed by them, my lords. As seen in from page number 106 to 110, my lords. My lords, and they have not showed, they have not complied with 154.1 and 154.3, my lords, as per Priyanka Srivatsa judgment, my lords.
Then
My lords, if we come into the merits of the case, my lords, the first agreement, my lords, it's a civil suit, my lords, which has taken the color of a criminal complaint and a criminal case is filed, my
what
lords.
is the allegation?
My lords, the allegation is that, my lords, I had filed a specific performance case, my lords, against them because there is a.
For that, my lord, I have also obtained certified copy of the affidavit, everything that last time which is argued. And therefore, my lord, that
You have filed the affidavit?
affidavit, yes. Therefore, my lord, we are producing that.
My lords, on the merits of the matter, my lords.
Where is it? Page number?
Page number 21, my lord. Complaint at page number 26.
Yes.
My lords, getting into the merits of the matter, my lords. My lords, I had filed a OS number 893 of 20, OS number 902 of 2019, my lords. Wherein I had filed a suit for specific performance.
filed?
I filed a suit for specific performance.
Andre, there are two petitioners, sir.
My lords, petitioner number 2 filed suit for specific performance, my lords, who is accused number 2 herein. My lords, when the summons of this specific performance suit had reached to the respondents herein, then they have subsequently filed this complaint, my lords, is what is my contention, my lords. The specific performance suit was filed against, my lords,
the agreement of sale dated OS number 893 of 2019. Well, it's annexure M is the order sheet, my lords, of the specific performance case that I had filed against the respondents.
Yes, agreement to sell dated.
My lords, the agreement to sell is dated, my lords, 2019, my lords.
You come prepared, sir. You come prepared with all dates and events.
My lords, the agreement to sell.
ಒಂದು ಕ್ವಶನ್ ಕೇಳಿದ್ಮೇಲೆ 10 ನಿಮಿಷ ತಗೊಳ್ತೀರ ಅದನ್ನು ಹುಡುಕೋದಕ್ಕೆ.
My lords, 15/2/2019 is the agreement to sell, my lords. Based on the same agreement to sell.
Hear you tomorrow.
Obligation.
ಬೇರೆ ಎಲ್ಲ ಅದು ನಾಳೆ ಅಷ್ಟೇ. Please come prepared.
Obligation, my lords, pardon.
Can I make a submission, my lord? Insofar as PCR filed, my lord, that they have, my lord, cheated us. Because, my lord, agreement which they are referring, that they are saying, my lord, that they have filed original suit. However, my lord, that they have said, my lord, to get kata and other things in respect of the property. And in that, my lord, that GPA which they have taken to get kata and then sale deed registered. Specific performance suit has been filed thereafter.
Sale deed was registered in favor of?
In favor of, kindly see, should the in favor of, my lord, Ganesh KV.
So sale deed in favor of third party.
Third party.
My lords, there is a annexure D, my lords, which is a GPA given by him, my lords, along.
That is what GPA created and the.
Prepared.
Along with the registered GPA has given us power to.
Sir, you should be very thorough with the facts, at least.
Oblige, my lords, then. Tomorrow, my lords, I will be.
ಕೇಳಿದ್ಮೇಲೆ ಮತ್ತೆ 10 ಕಡೆ ಹುಡುಕೋದಲ್ಲ ಅಲ್ಲಿ.
Pardon me, my lords, tomorrow.
Yes, come prepared.
That list of document may be.
ಆಯ್ತು, counsel for respondent number 2 filed memo along with list of documents.
Copy also, sir.
Yes.
My lords, interim order may be extended till tomorrow.
ಆಯ್ತು, ಇವತ್ತು ಇದ್ರೆ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಅಡ್ಮಿಷನ್ ಕಡಿಮೆ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳ್ರಿ. ಸುಮ್ಮನೆ ಅಡ್ಮಿಷನ್ನೇ ಆಗೋದಿಲ್ಲ, ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾವುದೂ ಆಗ್ತಾ ಇಲ್ಲ. ಇವು ರಿಪೀಟ್ ಮಾಡಿ ನಾಳೆಗೆ. ಅಡ್ಮಿಷನ್ ಕಡಿಮೆ ಹಾಕಿ ಇದನ್ನ ರಿಪೀಟ್ ಮಾಡಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ tomorrow it will be listed. Yes, tomorrow. ಇಲ್ಲ ಅದೇ ಸರಿ, ಬಟ್ ಟುಮಾರೋ ಐ ವಿಲ್ ಟೇಕ್ ಅಪ್ ದಟ್ ಫೈನಲಿ. ನಾಳೆ ಫುಲ್ ಆಗಿದೆ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Please, my lord, may I make no submission, my lord? Seal number 31, my lord, for final hearing. Taken up on Friday, my lord.
31,
31, my lord.
ಫ್ರೈಡೇ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ಫ್ರೈಡೇ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಆಗುತ್ತೆ.
Monday, my lord.
ಮಂಡೇ.
Interim order may be extended.
Yes. 29 ನೋಡಿ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲಿದೆಯೋ ಅದನ್ನ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಎಸ್
29
ಟುಮಾರೋ ಆಗಲ್ಲ ಸರ್, ಆಲ್ರೆಡಿ ಲಿಸ್ಟೇ ಪ್ರಿಪೇರ್ ಆಗೋಗಿತ್ತು.
Any day convenient to the court. Next Tuesday, madam. Next Tuesday. Any day convenient to the court.
ನೋಡಿ ಅದು ಯಾವ ಡೇಟ್.
Twenty-eight, madam.
ಮೇಡಮ್ 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 ಎಂಟ್ರಿ ಮಾಡಿರೋದೆಲ್ಲ ಕಳಿಸ್ತೀನಿ ಇದೇ ಇರೋದು ಇಲ್ಲೇ ಇಟ್ಕೊಂಡು ಏನ್ರಿ